Gothic Publications livestream. Today's subject is about remedial law review with case updates, jurisdiction, civil procedure, provisional remedies, and special civil actions. To be discussed by our guest lecturer, Attorney Purdey P. Perez.
Okay, good afternoon to everyone. Magandang hapon po sa inyong lahat at sana po ay nasa mabuti kayong kalagayan kung saan man kayo naroon. So wherever you are, stay safe. All right, now, first of all, I'd like to thank the Gothic Publications for having this free webinar lecture in remedial law. Now, since this is a 2 to 3 hours lecture, we will only discuss the basic and most important principles and rules in civil procedure. Now, in our lecture, we will use this PowerPoint presentation para naman hindi nakafocus yung mukha niyo sa mukha, hindi nakafocus kayo sa mukha ko. Kundi para meron din po kayong nababasa, nasusulat, at mahigit sa lahat, napipicturan. Diba? Kalimitan, pinipicturan na lang natin ating mga PowerPoint presentation. Now, having said that, let us start with our topic for today, remedial law review with case updates. Of course, we'll discuss some jurisprudence, recent jurisprudence in remedial law. Now, okay, let's start. Now, first is the basic doctrines in remedial law. Number one, doctrine of hierarchy of courts. Now, what is this doctrine of hierarchy of courts? Now, where the courts have concurrent jurisdiction over a subject matter, a case must be filed before the lowest court possible having the appropriate jurisdiction. Now, a practical judicial policy designed, this doctrine is a practical judicial policy designed to restrain parties from directly resorting to a higher court when relief may be obtained before the lower courts. Now, example, the Supreme Court has original jurisdiction and concurrent jurisdiction over petitions for certiorari prohibition in mandamus with the Court of Appeals and Regional Trial Court. Now, the operative word here is the concurrent jurisdiction. So if the courts have no concurrent jurisdiction, then this doctrine of hierarchy of courts will not apply. So that is the doctrine of hierarchy of courts. Now, it's also important to determine and to know the significance of observance of hierarchy of courts. In the case of Just Summer Incorporated versus Department of Transportation, a 2019 case, the court ruled that hierarchy of courts is a constitutional imperative. It is a constitutional imperative given first the structure of our judicial system. Kasi our courts have original, exclusive, concurrent, and appellate jurisdiction. Second, the requirements of due process, whether it is procedural due process or substantive due process. Another is that hierarchy of courts as a filtering mechanism. It operates to prevent first the inordinate demands upon the court's time and attention, which are better devoted to those matters within its exclusive jurisdiction. Number two, it operates to prevent further overcrowding of the court's docket. And number three, it operates to prevent inevitable and resultant delay, intended or otherwise, in the adjudication of cases, which often have to be remanded or referred to the lower court as the proper forum under the rules of procedure, or as the court better equipped to resolve factual questions. So this is the case of Just Summer Incorporated versus Department of Transportation, a 2019 case. This hierarchy of courts as a filtering mechanism. Kasi di ba maraming kaso na umaakyat sa Supreme Court that eventually it will be remanded to the lower court, especially to resolve and determine the factual issues of the case. Kasi kung ididiretso sa Supreme Court, wala nang gagawin ang Supreme Court kung hindi mag-resolve ng factual issues. Now remember, it is settled that the Supreme Court is not a trier of facts. The functions of the court, especially in a petition for certiorari under Rule 45, is limited to reviewing errors of law of the lower courts. Now, the determination of questions of fact is best left to the lower courts. So that is why the hierarchy of courts as a filtering mechanism. So, fang filter. All right. Next. Now, is the doctrine of hierarchy of courts absolute? The answer is no. In several cases, the Supreme Court enumerated several exceptions. First exception is when the case involves transcendental importance. Now, what is this transcendental importance? Transcendental importance is when there is an eminent threat to fundamental constitutional right that will outweigh the necessity for prudence, as cited in Perez versus the Senate, the 2020 case. Now, in the case of the Diocese of Bacolod versus Comelec, a 2015 case, so naalala niyo yung case na yung tarpaulin with Team Buhay or Team Patay, the Comelec there issue a notice to remove those tarpaulin. So ang issue doon is whether or not the right to suffrage includes the right of freedom of expression. So sabi ng court, the court said there is a clear threat to the paramount right of freedom of speech and freedom of expression, which warrants invocation of relief from the court. The right to suffrage not only includes the right to vote for one's chosen candidate, but also the right to vocalize that choice to the public in general in the hope of influencing the votes. The protection of these fundamental constitutional rights, therefore, allows for the immediate resort to the court. So it involves a transcendental importance as to whether the right to suffrage includes the right of freedom of expression. The same ruling in Perez versus the Senate, the 2020 case, ang dito naman is they question the constitutionality of anti-hazing law, yung RA 8049 as amended by RA 11053, directly to the Supreme Court. But the court, in this case, the court said the RTC there has jurisdiction to resolve the constitutionality of a statute. Kasi petitioner here claims that Section 14 of anti-hazing law is unconstitutional because the mere presence of the accused without direct participation during a hearing, during a hazing, is a prima facie evidence of his or her participation, and it relates to the conspiracy in the crime. So, sabi ng petitioner, it involves a transcendental importance for the court to resolve. Again, sabi ng Supreme Court, no, settled na yan. The court has long upheld the constitutionality of disputable presumptions in criminal laws. The constitutional presumption of innocence is not violated when there is a logical connection between the fact proved and the ultimate fact presumed. So that is one of the exceptions when the case involves transcendental importance. So if they have no transcendental importance on the part of the court, then then the doctrine of hierarchy of court should be observed, shall be observed. All right. Now, next, another exception is when the case is novel or of first impression. What do you mean by this? According to the court in the Diocese of Bacolod versus Comelec, a 2015 case, a case is novel or of first impression if no jurisprudence yet exists that will guide the courts on this matter. Now, example, in the case of Government of US versus Forganan, a 22 case where the issue is the right to bail in extradition proceedings. In that case, the court said this is a first impression. So that's why the Supreme Court took cognizance of that case, disregarding the doctrine of hierarchy of courts. The same is true with the Diocese of Bacolod versus Comelec, a 2015 case, yung kaninang case. The right of suffrage includes the right of freedom of expression. So when the case is novel or of first impression, the doctrine of hierarchy of courts may be disregarded. Another exception, yung mga memes po dyan, pampalis lang po yan ng antok kasi masyadong ang remedial is very procedural. So talagang para maalis naman ang ma-enjoy natin. Again, sana mag-enjoy kayo dito sa presentation, not only on the law, but sa mga beams natin. All right, next. Another exception is when there are genuine issues of constitutionality that must be addressed at the most immediate time. Now, what are the remedies to assail the constitutionality of actions of both legislative and executive branches of the government? In Aquino versus Comelec, a 2010 case, the court ruled that a direct resort to the Supreme Court includes availing of the remedies of certiorari and prohibition to assail the constitutionality of actions of both legislative and executive branches of the government. Now, again, in the case of the Diocese of Bacolod versus Comelec 2015, in this case, the court ruled that the assailed issuances of Comelec prejudiced not only petitioners' right to freedom of expression in the present case, but also others in the future similar cases. It involves an active effort on the part of the electorate to reform political landscape. This has become a rare occasion when private citizens actively engage the public and political discourse. As such, the right to engage in free expression of ideas must be given immediate protection by this court. Here, there is a genuine issues of constitutionality of whether or not the right to freedom of expression includes the right to vote or the right of expression, free expression. All right, now. Another exception to the doctrine of hierarchy of courts is when the constitutional issues raised are better decided by the court. Now, in Drilon versus Lim 1994 case, the court said it will be prudent for such courts, the lower courts, if only out of a becoming modesty, to defer to the higher judgment of the court in consideration of its validity, which is better determined after a thorough deliberation by a collegiate body and with the concurrence of the majority of those participated in its discussion. In other words, sabi ng Supreme Court, mas magaling kami. So parang in effect. So, well, practically tama naman kasi sa lower court, judge lang ang magde-decide. Pag sa Court of Appeals or better Supreme Court, this is a collegial body. So maraming justices na magde-decide. So sabi na, it is better to be decided by the court if it involves constitutional issues. All right. Next. Okay, now another exceptions when time is of the essence. Again, in the case of the diocese of Bacolod versus Comelec, the court said the time element presented in this case cannot be ignored. This case was filed during the 2013 election period, although the elections have already been concluded. Future cases may be filed that necessitate urgency in its resolution. Exigency in certain situations would qualify as an exception for direct resort to these courts. So there is a time element there. That's why the court said, diretso na sa kanila. Disregard the doctrine of hierarchy of courts. So anong oras na? Now, another exceptions is when the subject of review involves acts of a constitutional organ. You all know what are those constitutional bodies, right? COMELEC, COA. Now, in Albano versus Arans, in an old 1962 case, the court said it is easy to realize the chaos that would ensure if the court of first instance, now the RTC, of each and every province were arrogate itself the power to disregard, suspend, or contradict any order of the Commission on Elections. That constitutional body will be speedily reduced to impotence. So if the RTC would take cognizance of the case, then that will reduce to impotence on the part of the constitutional organ. Again, in the Diocese of Bacolod versus Comelec, the court said if petitioners sought to annul the actions of Comelec through pursuing remedies with the lower courts, any ruling on their part would not have been binding for other citizens whom respondents may place in the same situation. Besides, the court affords great respect to the Constitution and the powers and duties imposed upon Comelec. All right, now, next exception. So 7, when there is no other plain, speedy, adequate remedy in the ordinary course of law. Number 8, when the petition includes questions that may affect public welfare, public policy, or demanded by the broader interest of justice. Number 9, when the order complained of was a patent nullity. And number 10, when the appeal was considered as an inappropriate remedy. Now, these enumerations was reiterated in Aala versus Oy at 2017 case. Okay, now, that is the doctrine of hierarchy of courts and there in its exceptions. Now, let's move to another doctrine, the doctrine of non-interference or judicial stability. Under this doctrine of non-interference or judicial stability, the courts of equal and coordinate jurisdiction cannot interfere with each other's orders. Court is barred from reviewing or interfering with the judgment of a co-equal court over which it has no appellate jurisdiction or power of review. In the old case of Villamor versus Salas, the court said that this doctrine of non-interference or judicial stability applies with equal force to administrative bodies. All right, now next is the doctrine of the law of the case. What is this doctrine of the law of the case? Is the opinion rendered on a former appeal. Now, in Francisco versus Batung, a 2019 case, the court ruled that while petitioner's action for specific performance and respondent's action for unlawful detainer, which was the subject of Court of Appeals review, involved a similar set of facts, there are two different cases. Thus, whatever ensuing incident in petitioner's action for specific performance cannot be considered a subsequent proceeding in the Court of Appeals case. Now, questions of law, not questions of fact, previously, under this doctrine of the law of the case, questions of law previously determined by a court will generally govern a case through all its subsequent stages where the determination has already been made on a prior appeal to a court of last resort, but not questions of fact. Now, in the same manner, the ruling of the appellate court cannot be deviated from in the subsequent proceedings in the same case. It applies only to the same case as held in this Francisco versus Batong 2019 case. Here, there is a similar set of facts, but these are two different cases. All right, now, another doctrine of the law of the case, still in the case of PD 1271 Committee versus De Guzman, a 2016 case, and the MRT Development Corporation versus Gamon, Philippines, a 2018 case, the court ruled that similar to doctrine of res judicata, the doctrine of law of the case is a refusal to reopen what has already been decided. So that if an appellate court has determined a legal issue and has remanded it to the lower court for further proceedings, another appeal in that same case should no longer differently determine the legal issue previously passed upon. All right, now next is the doctrine of finality of judgment or immutability of judgments. What is this doctrine? Now, under this doctrine, once a decision has acquired finality, it becomes immutable, unalterable, and may no longer be modified in any aspect, regardless if the modification is meant to correct erroneous factual and legal conclusions. As the purpose of this doctrine of finality of judgment is the orderly administration of justice. The orderly administration of justice requires that at the risk of occasional errors, the judgment of a court must reach a point of finality set by law. Litigation must somehow come to an end. So kailangan din may katapusan. So that's why this doctrine of finality of judgment is a good doctrine. Now, in the case of spouses Francisco versus Batong 2019 case, in this case, the court ruled that the doctrine does not apply here. Because in this case, the nature of the deed of conditional sale was incidentally passed upon in the action for unlawful detainer to determine the rights of petitioner and respondent relative to the ownership of the subject land so as to determine who is entitled to possession thereto. Such determination of ownership based on the deed is provisional. That is the word, provisional. That's not a conclusive adjudication on the merits of the case. So the doctrine of finality of judgment will not apply if the order of the decision is merely provisional or it's merely incidental, incidental in a case. Now, okay. So in the petition for certiorari, the Court of Appeals was not precluded. In other words, in a petition for certiorari, the Court of Appeals was not precluded to revisit the issue on the nature of the deed and make its ascertainment based on the facts and evidence on record. Kasi dito nga ang court is it was the nature of the deed of conditions. It was incidentally passed upon. So it has no conclusive adjudication the merits of it. Though wala pang adjudication on the merits of the case. So that's why the doctrine does not apply. So hindi pa immutable ang judgment kasi wala pang adjudication on the merits. Right now, the case of Gadrinal versus Salamanca, 2014 case, doctrines on bar by prior judgment and immutability of judgment apply whether judgment is rendered after a full-blown trial or after the parties voluntarily execute a compromise agreement duly approved by the court. Because a judicial compromise agreement is in the nature of both an agreement between the parties and a judgment on the merits. It is covered by the Civil Code provisions on contracts. Diba, yung res judicata has the effect of decision on the merits. So this doctrine does not apply only to judgment based on a full-blown trial, but also to a compromise agreement duly approved by the court, because a compromise agreement has the effect of res judicata. Okay. Now, next slide. Now, what are the exceptions to the doctrine of immutability of judgment? So the doctrine of immutability of judgment is not an absolute doctrine. So it has exceptions. Now, what are these exceptions? First exception is when the judge for correction of clerical error. There's a clerical error. So the court may correct that clerical errors without violating the doctrine of immutability of judgment. Second exception is the non-proton entry. It is an entry made now of something which was actually previously done to have effect as of the former date. Now, the office or the purpose of the non-proton is not to supply omitted action by the court, but to supply an omission in the record of action readily had, but omitted through inadvertence or mistake. So wala nang bitaw, nagkaroon na ng hindi na na-omit na information na hindi na isama sa decision. So non-proton entry or non-proton judgment will not violate the doctrine of immutability of judgment. Now, in Briones Vasquez versus Court of Appeals, a 2005 case, the court ruled that the object of a judgment non-proton is not the rendering of a new judgment and ascertainment and determination of new rights, but is one placing in proper form on the record the judgment that had been previously rendered to make it speak the truth. Okay, now another exception is when a judgment is void or void judgment. Now, a void judgment is in effect a no judgment at all, and all acts performed under it and all claims flowing out of it are void. So walang bisa, null and void. Wala. Now, in Lingkod Manggagawa's Rubber World versus Rubber World 2007 case, the judgment is vulnerable to attack even when no appeal has been taken and does not become final in the sense of depriving a party of his right to question its validity. Now, in Tesda versus Abragar at 2021 case, the failure to implead Tesda and the other parties to the MOA renders the decision of the labor arbiter and writ of execution null and void for want of authority, which may be attacked in any way at any time, even when no appeal is taken. Now, it is immaterial that TESDA filed the appeal memorandum in intervention after the labor arbiter judgment became allegedly final and executory, since the judgment void ab initio is non-existent and thus cannot acquire finality. So a void judgment can never acquire a finality. So it will never violate the doctrine of immutability of judgment. Okay. Wala na, finish na po yan. Now, another exception is whenever circumstances transpire after the finality of the decision, rendering its execution unjust and inequitable. Example po nito, in a case, the clerk of court issued entry of judgment. No, we all know that the entry of judgment is the certification that the case is final and executory. Now, however, it appears on record that there is a motion for reconsideration filed within the reglementary period. So, pumasok yung file niya. But due to inadvertence or due to napansin ng clerk of court, the MR was not considered. Therefore, the judgment will not attain finality because there is a circumstances that will render its execution unjust. So kasi may MR naman na filed on time pero hindi lang napansin na clerk of court, then nag-issue siya ng entry of judgment. Then that circumstances render its execution unjust. Now, normally the remedy of that party is to file a motion to lift entry of judgment. So the court will simply cancel or lift the entry of judgment so that they can file a motion for reconsideration or appeal. Okay. Now, next doctrine is the doctrine of exhaustion of administrative remedies. Under this doctrine, a party must first avail of all administrative processes available before seeking the court's intervention, as held in Republic versus Gallo, a 2018 case. Now, in this doctrine of exhaustion of administrative remedies, the administrative officer concerned must be given every opportunity to decide on the matter within his or her jurisdiction. Now, the failure to observe the doctrine of exhaustion of administrative remedies does not affect the jurisdiction of the court. The only effect of non-compliance is that it will deprive the complainant of a cause of action. So a non-observance of this doctrine will not affect the jurisdiction of the court. Now, in the case of Soto versus Herreno, the court ruled that if this doctrine of exhaustion of administrative remedies is not invoked at the proper time, the ground for non-compliance of exhaustion of administrative remedies is deemed waived, and the court can then take cognizance of the case and try it. So it must be invoked at the proper time. Okay, now, exceptions to the doctrine of exhaustion of administrative remedies. In a catena of case, the court enumerated the exceptions to this doctrine. Now, first, when there is estoppel on the part of the party invoking the doctrine, estopped by laches. Now, second, where the challenged administrative act is patently illegal, amounting to lack of jurisdiction. Third, when there is unreasonable delay or official inaction that will irretrievably prejudice the complainant. Fourth, where the amount involved is relatively small so as to make the rule impractical and oppressive. Fifth, where the question involved is purely legal and it will ultimately have to be decided by courts of justice. Six, where judicial intervention is urgent. Number 7, when its application may cause great and irreparable damage. Number 8, where the controverted acts violate due process. 9, when the issue of non-exhaustion of administrative remedies has been rendered moot. 10, when there is no other plain, speedy, and adequate remedy. And 11, when strong public interest is involved. And 12, in quo warranto proceedings. Now, these are the exceptions to the doctrine of exhaustion of administrative remedy. So if these exceptions is available, if these exceptions is present, then the doctrine can be disregarded. Now, next doctrine is the doctrine of primary administrative jurisdiction. What is this doctrine? Now, if an administrative tribunal has jurisdiction over a controversy, courts should not resolve the issue, even if it may be within its proper jurisdiction. In other words, the doctrine of primary administrative jurisdiction refers to the competence of a court to take cognizance of a case at first instance. Now, this doctrine is especially true when the question involved is the sound discretion of the administrative agency that requires special knowledge, experience, and service to determine technical and intricate matters of fact. Now, in this case of Republic versus Gallo 2018 case, this is similar to the case of Tiham versus Sibonghano, di ba? Where a party participated in the proceedings and the issue of non-compliance was raised only as an afterthought. At the final stage of appeal, the party invoking it may be stopped from doing so. Now, unlike the doctrine of exhaustion of administrative remedies, this doctrine of primary administrative jurisdiction cannot be waived. However, for reasons of equity, in some cases, the court ruled that where jurisdiction is lacking, the court has ruled that failure to raise the issue of non-compliance with this doctrine of primary administrative jurisdiction at an opportune time may bar a subsequent filing of a motion to dismiss based on that ground by way of laches. So, doctrine of exhaustion of administrative remedies as a rule may be waived. Doctrine of primary administrative jurisdiction as a rule, it cannot be waived except in case where lack of jurisdiction is involved. Okay. Next, exceptions to the doctrine of primary administrative jurisdiction. Now, those exceptions in the doctrine of exhaustion of administrative remedies are the same exception in this doctrine of primary administrative jurisdiction. The same, all right? Now, another doctrine is the doctrine of adherence of jurisdiction or continuity of jurisdiction. Meaning, once jurisdiction has been acquired, it continues until the court finally disposes of the case. Question. Plaintiff filed a complaint for collection of money amounting to 500,000 against respondent before the RTC. However, during the trial, it was proved by the respondent that the plaintiff is entitled only to 100,000. Now, respondent seek for a dismissal of the complaint on the ground that the RTC has no jurisdiction over a claim because less than the jurisdictional amount. Now, should the motion be granted? Now, applying this doctrine, no. Under doctrine of adherence of jurisdiction, once the court acquires jurisdiction over the case, the court continues to exercise such jurisdiction until its final adjudication, even if the amount involved or awarded is below the jurisdictional amount under the law. Okay. Now, that is the doctrine of adherence of jurisdiction. So now, let's proceed to jurisdiction in civil cases. So, jurisdiction na po tayo. So, yung mga nabanggit na doctrines ay yung pa mga importante. Although there's specific doctrines in remedial law, but we can discuss that in subsequent presentation. Now, let's proceed to jurisdiction in civil cases. So, jurisdiction lang po to sa civil cases. Jurisdiction. Jurisdiction is the power and authority of the court to hear, try, and decide a case, and to enforce or execute its judgments or final orders. As selling Cuenca versus PCGG and Ichigaray versus DOJ. So, kasi hindi lang yung mag-hear and try to decide the case, but also enforce or execute the judgment. Kasi normally na question yung parang, wala na yung kasi execution na. Sa sheriff na yan. So, yung sheriff, ang duty naman is ministerial to execute. But again, the court has control over the sheriff. Now, when jurisdiction acquired over the plaintiff and defendant. Now, when is jurisdiction acquired over the plaintiff and the defendant? Plaintiff upon filing of complaint or petition or other initiatory pleading. So once the plaintiff file a complaint or petition or other initiatory pleading, the court acquire jurisdiction over the person of the plaintiff. How about dependent? The court acquired jurisdiction over the person of the defendant upon service of summons. But this service of summons must be a proper or valid service of summons. Otherwise, the court will not acquire jurisdiction. Another is voluntary appearance in court. Now, once the defendant voluntarily enters his appearance in court, it is equivalent to service of summons. Okay, now. All right. Now, let's move to the outline of jurisdiction in civil cases. So let's start with the MTC, or Municipal Trial Court, Metropolitan Trial Court, Municipal Circuit Trial Courts, and Municipal Trial Courts in cities. So MTC in civil cases. The Municipal Trial Court in civil case has original and exclusive jurisdiction over these actions. Number one, actions involving personal property whose value does not exceed 2 million pesos, exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and costs under the new law, the RA 11576, which took effect on July 30, 2021. Before, in Metro Manila, the amount is 400,000, di ba? Sa outside Metro Manila, 300,000, but now does not exceed 2 million pesos. In actions demanding sums of money, same, not exceeding 2 million pesos, exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and cost. And number three, actions in admiralty and maritime jurisdiction where the demand or claim does not exceed 2 million pesos. Again, exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and costs. Another, probate proceedings, testate or intestate, where the gross value of the estate, again, does not exceed 2 million pesos. Next, number five, actions involving Title II or possession of real property or any interest therein, where the assessed value of the property, of that property, does not exceed 400,000 pesos, exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and cost. So this is the new amendment of, this is the law RA 11576. Before, the amount is, if within Metro Manila is 50,000, it does not exceed 50,000. If outside Metro Manila, 20,000. Now, it does not, the assessed value of the property must not exceed 400,000 pesos. Now, another is the MTC has original exclusive jurisdiction over forcible entry and unlawful detainer cases. Now, automatic yan pag forcible entry, unlawful sa MTC. Now, the MTC has this delegated jurisdiction. Now, cadastral or land registration cases covering lots where there is no controversy or opposition or contested lots, the value of which does not, as of now, 100,000. So, wala pang nilalabas na circular ng Supreme Court whether it will be increased. Because under the amendment, under the RA 11576, no specific jurisdictional amount provided there. But the law authorizes the Supreme Court to adjust the jurisdictional amount to reflect the extraordinary supervening inflation or deflation of currency and land valuation. So as of date, to my knowledge, wala pang circular kung na-increase na ba itong 100,000 or the same pa rin. So that is the delegated jurisdiction of the MTC. The MTC has also special jurisdiction over petitions for habeas corpus in the absence of all the regional trial judges in the province or city And summary procedure, enforceable entry, and unlawful detainer cases, irrespective of the amount of damages or unpaid rentals sought to be recovered. So even if the amount of damages or unpaid rentals sought to be recovered is 2 million, if it is a case of forcible entry, an action for forcible entry and lawful detainer, still the jurisdiction with the MTC as a summary procedure. Now, next is the regional trial court in civil cases. Now, what are the jurisdiction of the regional trial court in civil cases? Original and exclusive. First, actions in which the subject of litigation is incapable of pecuniary estimation. Now, what is incapable of pecuniary estimation? These are actions where the principal relief sought is not a claim for sum of money or the assertion of title to or possession of property. So that's why it is incapable of pecuniary estimation. Example, specific performance, an action for specific performance, rescission or annulment of contract, injunction, declaratory relief, reformation of contract, action for revival of judgment, and action for abatement of nuisance. Now, these actions does not involve a claim for sum of money or assertion of title to or possession of. So that's why these are incapable, these are actions incapable of pecuniary estimation. Another action is actions involving title to or possession of real property or any interest therein where the assessed value this time exceeds 400,000 pesos, exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, in costs under RA 11576. So before, more Metro Manila, more than 50,000, outside Metro Manila, 20,000. But now, exceeds 400,000. Third, actions in admiralty and maritime jurisdiction where the demand or claim exceeds 2 million pesos, exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and costs. At MTC, below, it does not exceed 2 million, RTC exceeds 2 million pesos. Another is probate proceedings, testate or intestate, where the gross value of the estate exceeds 2 million. If it does not exceed 2 million, MTC. Now, another is other cases in which the demand, exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and cost or the value of the property in controversy exceeds 2 million pesos. Next, actions involving marriage and marital relations. Actions for recognition and enforcement of arbitration agreement, vacation or modification of arbitration award, application for arbitration award, and supervision under the ADR of 2004. Another is actions for annulment of MTC judgments. Another, cases not within the exclusive jurisdiction of any court, tribunal, person, or body exercising judicial or quasi-judicial functions. Remember, RTC is a court of general jurisdiction. Now, RTC as a family court, because there are RTC now that are designated as family court. So they have jurisdiction over petitions for guardianship, custody of children, and habeas corpus in relation to the latter. Habeas corpus in relation to the custody of children. Petitions for adoption of children and revocation thereof. Third, complaints for annulment or nullification of marriage, those relating to marital status and property relations of spouses or those living together under different status and agreements, and petitions for dissolution of conjugal partnership of gains. Another, petitions for support and or acknowledgement, summary judicial proceedings under the Family Code. Now, some RTC are also designated as special commercial court. Now, jurisdiction over the special commercial court are first, cases involving violations of intellectual property rights. Next, cases enumerated under Section 5, PD 902A, which is the fraud scheme cases, intracorporate disputes, election cases, petitions for suspension of payment, and or rehabilitation proceedings. Rehabilitation, insolvency, and liquidation cases under the Financial Rehabilitation and Insolvency Act of 2020 and those emanating from administrative proceedings. Also, the RTC as Special Agrarian Court. It has original and exclusive jurisdiction over all petitions for the determination of just compensation to landowners. Now, the RTC has concurrent jurisdiction first with the Supreme Court as to actions affecting ambassadors, other public ministers, and consuls. The RTC has also concurrent jurisdiction with the Supreme Court and Court of Appeals over petitions for certiorari, prohibition, mandamus against lower courts and bodies, and petitions for habeas corpus and quo warranto. The RTC has also concurrent jurisdiction with the Supreme Court, Court of Appeals, and Sandigan Bayan over petitions for writ of amparo and habeas data. And the RTC has appellate jurisdiction over all cases decided by the MTCs in their respective territorial jurisdictions. Now, that is the jurisdiction of the Regional Trial Court in civil cases. Now, how about the Court of Appeals in civil cases? The Court of Appeals has original and exclusive jurisdiction over actions for annulment of judgment of RTCs. It has also jurisdiction over special civil action or certiorari against a regional trial court's order approving or disapproving the rehabilitation plan or any order issued after the approval of the rehabilitation plan. Court of Appeals has concurrent jurisdiction with the Supreme Court on petitions for certiorari, prohibition, mandamus against the RTCs, and concurrent jurisdiction with the Supreme Court and regional trial courts on petitions for certiorari, prohibition, mandamus against courts of the first level and other bodies, and petitions for habeas corpus and quo warranto. Concurrent jurisdiction with the Supreme Court, Sandigan Bayan, and regional trial courts on petitions for writ of amparo and habeas corpus. Now, the Court of Appeals has appellate jurisdiction over ordinary appeals from the regional trial courts, except in cases exclusively appealable to the Supreme Court, family courts, special commercial courts. Jurisdiction over appeal by petition for review under Rule 43 from quasi-judicial agency, instrumentality, board, or commission in the exercise of quasi-judicial functions like the Securities and Exchange Commission, Land Registration Authority, Civil Service Commission, etc. Petitions for review under Rule 42 from the regional trial courts in cases appealed thereto from the lower courts and from RTC acting as a special agrarian court. Now, let's move to the jurisdiction of the Supreme Court in civil cases. Original jurisdiction and exclusive over petitions for certiorari, prohibition, mandamus against Court of Appeals, COMELEC, Commission on Audit, Court of Tax Appeals, and Sandigan Bayan. The Supreme Court has concurrent jurisdiction with the Court of Appeals on petitions for certiorari, prohibition, mandamus against the RTCs. Supreme Court has also concurrent jurisdiction with the Court of Appeals and regional trial courts on petitions for certiorari, prohibition, mandamus against courts of the first level and other bodies and petitions for habeas corpus and quo warranto. Concurrent jurisdiction with regional trial courts on actions against ambassadors, other public ministers, and consuls. The Supreme Court has also concurrent jurisdiction with the Sandigan Bayan on petitions for certiorari, prohibition, mandamus, habeas corpus, injunctions, and ancillary writs in aid of its appellate jurisdiction and over petitions of similar nature, including quo warranto and PCGG cases. And with concurrent jurisdiction with Court of Appeals, Sandigan Bayan, and Regional Trial Court on petition for writs of amparo and habeas data. Now, the Supreme Court has appellate jurisdiction over petitions for review on certiorari against Court of Appeals, Sandigan Bayan, Regional Trial Courts in cases involving, first, constitutionality or validity of a treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulation. Second, legality of a tax, imposed, assessment, toll, or a penalty in relation thereto. Next, jurisdiction of a lower court. And last, appellate jurisdiction over pure error or question of law. The Supreme Court has also appellate jurisdiction over Court of Tax Appeals and Bank, and final judgment or order in a writ of amparo or habeas data. So that is the jurisdiction of the MTC, RTC, Court of Appeals, and the Supreme Court. Now, let's move to venue of actions. So kanina nakita natin jurisdiction. Ngayon, punta naman tayo sa venue. Now, venue is the place of trial or geographical location in which an action or proceeding should be brought. In civil cases, venue is procedural, not jurisdictional, and hence may be waived. It is intended to provide convenience to the parties. In other words, venue is a matter of procedural law. Thus, objection on venue must be raised at the earliest opportunity. Now, what is this earliest opportunity in civil action? Procedurally, it should be raised in a motion to dismiss or pleaded in the answer, or pleaded as an affirmative defense in the answer. However, under the new rules, an improper question on venue or improper venue is now a prohibited ground for motion to dismiss. This can only be pleaded as an affirmative defense in the answer. So before, pwede yan sa motion to dismiss. Ngayon, hindi na pwede. So it is a prohibited pleading na. So if you will file a motion to dismiss on the ground of improper venue, that is a prohibited pleading. Pwede mong gawin yan sa answer. You can raise that as an affirmative defense in the answer. Okay, now in Radio Wealth Finance versus Pineda at a 2018 case, the court ruled that when the venue of a civil action is improperly laid, the court cannot mutu proprio dismiss the case. Kaya nga sa akin nga, sa motion to dismiss, hindi na pwede yan. Now, in Cabrera versus PSA, a 2019 case, the court ruled that it was error for the RTC Branch 14 to dismiss the refiled petition mutu proprio. It is well settled that courts may not mutu proprio dismiss the case on the ground of improper venue without any objection at the earliest opportunity, as in a before motion to dismiss, or in the answer, it is deemed waived. So again, improper venue is not a ground for motion to dismiss. It is a prohibited motion based on that ground. It can only be raised in the affirmative defense as an answer, as affirmative defense in the answer. All right. So may tagpuan sa venue. Now, rules on venue. Venue of action in civil cases. what is the venue of action in civil cases? First, you should distinguish whether it is a personal action or real action. Now, real action is the place where the area of real property involved or a portion thereof is situated. So the venue in real action is the place where the area of real property involved or a portion thereof is situated. Now, in personal action, the venue is the place where the plaintiff or any of the principal plaintiffs resides, or where the defendant or any of the principal defendants resides, or in the case of a non-resident defendant, where he may be found at the election or at the option of the plaintiff. Now, first, real actions. What are those real actions? These are actions affecting title to or possession of real property or interest therein. So an example of real action is an action to recover ownership or possession of land, which includes the action publicana, action reivindicatoria, and action interdictal, foreclosure of real estate mortgage, partition, and ejectment. These are real actions because it affects title to or possession of real property or interest thereof. Now, what is a personal action? Personal actions are those that does not affect title to or possession of real property or interest therein. An example of personal action is an action to recover personal property, action for specific performance, action for collection of sum of money, and enforcement of a contract or recovery of damages and annulment of contract. Now, these are personal action. The venue of these actions is the place where the plaintiff or any of the principal plaintiffs resides, or where the defendant or any of the principal defendants reside, or in case of a non-resident defendant, where he may be found at the election of the plaintiff. Now, for purposes of venue, it is important to determine whether an action is real action or personal action. Kasi magkakamali ka ng venue pag real action yung case, mali yung mali yung venue mo. Okay, now in Pilipinas Shell versus Royal Ferry, a 2017 case for a corporation, this time corporation, its residence is considered the place where its principal office is located as stated in its articles of incorporation. So suppose the plaintiff or defendant is a corporation. Now the venue is the place where its principal office is located as stated in its articles of incorporation. Kasi karamihan sa mga corporation, marami silang offices, di ba? So you can determine that sa articles of incorporation kung saan yung principal office na naka-registered sa SEC sa kanilang articles of incorporation. Now, in Latore versus Latore, a 2010 case, the court ruled that what determines the venue of a case is the primary objective for the filing of the case. Now, in criminal cases, venue is jurisdictional as compared in civil. In civil, venue is not jurisdictional and merely procedural. Venue in criminal cases is jurisdictional. The place where the crime, because in criminal cases, it is the place where the crime was committed, where it determines not only the venue of action, but it is an essential element of jurisdiction. In other words, the place where the crime was committed determines not only the venue of the action, but is an element or essential element of jurisdiction. So essential element of jurisdiction ang venue sa criminal cases. Now, it is a fundamental rule that for jurisdiction to be acquired by courts in criminal cases, the offense should have been committed or any of its essential ingredients should have been taking place within the territorial jurisdiction of the court. So that's why napaka-importante ng venue sa criminal cases because it is an essential element of a crime in some crimes, right? Now, okay. Now, but before we proceed to the filing of complaint, our next topic is filing of complaint, the civil procedure na. Let's take a 2-minute break. So, Madam, host, can we have a break? Good afternoon again. Welcome back. Now, let's resume. Kanina, we discussed the doctrines in remedial law, the jurisdiction of the court, and the venue of actions. Now, we all know na kung anong court ang may jurisdiction at kung saan ang venue ng actions. Now, we will file the necessary pleading, and that is complaint, filing of complaint. So, filing of complaint. But first, let us discuss the overview of the procedure. Now, procedurally, a civil action is initiated by filing a complaint in the appropriate court. Within 30 calendar days after the service of summons or as directed by the court, the defendant must file an answer before 15 days. With the new rules, 30 calendar days. Now, the 30 calendar days is extendable for another 30 days if there is a meritorious ground for the extension. But as a rule, 30 days lang, non-extendable. Now, if there is a meritorious ground, then the court may extend it for another 30 days. Now, a defendant who fails to timely file an answer shall be held in default. Right now, thereupon, the court shall proceed to render judgment granting the claimant such relief as his pleading or his or her pleading may warrant, unless the court, in its discretion, requires the claimant to submit evidence. Now, the filing of a complaint is not in all cases followed by the filing of an answer. Upon any of the grounds recognized by Rule 15, Section 12 of the new rules on civil procedure, a defendant may instead seek the immediate dismissal of the complaint only on the following grounds. Now, 4 grounds na lang. First, that the court has no jurisdiction over the subject matter or the so-called subject matter jurisdiction. Second, that there is another action pending between the same parties for the same cause or the litis pendentia. Third, that the cause of action is barred by prior judgment. And fourth, that the cause of action is barred by statute of limitations or prescription. The other one, that the cause of action is barred by prior judgment or res judicata. Now, there are only 4 grounds where a motion to dismiss may be allowed. Now, under the old rule, or Rule 16, a motion to dismiss is filed within the time for but before filing the answer. So that if a motion to dismiss is denied, the defendant shall then file an answer within the remaining period of the 15 days that he or she originally had to file it, but in no case less than 5 days. That was the old rule. Now, under the new rule, there is no similar rules on that, specific rules on that, because the entire Rule 16 on motion to dismiss was practically deleted. Now, since the defendant can file an answer to the complaint within 30 calendar days under the new rules after service of summons, the motion to dismiss should also be filed within the period of filing an answer, which is 30 days. Now, if the motion to dismiss is denied, the defendant shall then file an answer within the remaining period of 30 calendar days. Now, but suppose the remaining period of 30 days is 1 day only. So 1 day na lang. The remaining period of 1 day will still be the remaining day of filing the answer. Because sa new rules, hindi na nakalagay yung not less than 5 days. So kahit nag-file siya ng less than 1 day na lang, bibigyan pa rin siya ng court ng not less than 5 days. But here, under new rules, there is no such specific rule on that. So the governing rule now is that he has only the remaining period of 1 day if 1 day nila natitira. Now, again, but even if a motion to dismiss on the ground of subject matter jurisdiction, litis pendentia, res judicata, or prescription was filed after the period of 30 calendar days for filing an answer, the defendant may still raise said grounds as a motion to dismiss because these defenses are not waived pursuant to Section 1 of Rule 9. However, on the ground of lack of jurisdiction, an exception is estoppel by laches as held in Tiham versus Sibunghanoy. So kaya siguro hindi na nilagay yung remaining remaining 5 days to file kasi even after a motion to this, even after an answer has been filed, he can still raise that provided he will not be stopped. So as held in the case of Tiham versus Sibunghanoy kasi sa appeal na siya ni-raise yung lack of jurisdiction, so parang masyadong late na. As held in Tiham versus Sibunghanoy. So estoppel by laches. Now, the rules require that only the merits of the issues of a case are to be the subject of trial. The issues, however, will be joined only after an answer is filed. Now, in the answer, affirmative defenses, which take the form of confession and avoidance, may also be raised. After the answer, if no new defenses may be raised because wala nang bagong defenses may be raised because defenses and objections not pleaded in the answer are deemed waived, except of course the subject matter jurisdiction, litis pendentia, res judicata, and prescription. Now, it is during trial where evidence to prove the parties' respective positions on substantive issues as tendered in their pleadings is received. Judgment on the questions of fact as well as law on these substantive issues will then follow. So, yun ang pinaka-simple procedure ng filing of a complaint and filing of an answer and what will be the effect. Now, having said that, let us now proceed to the filing of a complaint. Now, when you file a complaint, of course, you must have a cause of action. Now, what is a cause of action? Ito pong nakita niyo po yung ating meme. So ito daw dahilan kung bakit binasted beauty si Paolo, ayaw mapalitan ng apelido kasi magiging beauty contest. So, nakita ko lang po yan kanina. Now, what is a cause of action? A cause of action is the act or omission by which a party violates a right of another under Section 2 of Rule 2. Now, what are the elements of causes or cause of action? First, there must be a right in favor of the plaintiff under whatever law it arises. Second, obligations on the part of the defendant to respect or not to violate such rights. And third, an act or omission on the part of the defendant violative of the right of the plaintiff. Now, these three elements or requisites must concur in order that there will be a cause of action. Again, right in favor of the plaintiff, obligations on the part of the defendant, and an act or omission on the part of the defendant violative of the right of the plaintiff. All right, now, may the plaintiff institute more than one suit for a single cause of action? Now, what is the effect? Answer, no. The plaintiff may not institute more than one suit for a single cause of action. Now, if two or more suits are instituted on the basis of the same cause of action, the filing of one or a judgment upon the merits in any one is available as a ground for the dismissal of the others. Now, what are these grounds? This is the litis pendentia, that there's another action pending between the same parties for the same cause, and res judicata, that the action is barred by prior judgment. Now, when can these grounds be raised? Under the new rules, it can be raised, this litis pendentia and res judicata can be raised in a motion to dismiss or as an affirmative defense in the answer. Again, these are the so-called grounds for dismissal of an action, which is not waivable. Next. All right, now. Failure to state cause of action versus lack of cause of action. So anong pagkakaiba po dito? Since we are talking of cause of action. Now, failure to state cause of action, it involves insufficiency of allegation in the pleading, while lack of cause of action involves insufficiency of factual basis for the action or insufficiency of evidence. In other words, in failure to state cause of action, the examination is limited to the complaint, in that whether it contains the averment of the three essential elements yung sinabi natin kanina, the right in favor of the plaintiff, the obligation of the part of the defendant, acts or omissions violated on the right of the plaintiff. Now, hence, the test is whether or not admitting hypothetically the allegations of fact made in the complaint, a judge may validly grant the relief demanded. Now, in contrast, a complaint lacks cause of action when it presents questions of fact that goes into proving the existence of the elements of the plaintiff's cause of action. Now, in other words, failure to state cause of action can be made at the earliest stages of an action, whereas lack of cause of action is usually made after questions of fact have been resolved on the basis of stipulations, admissions, or evidence presented during the trial. So another distinction, failure to state a cause of action may be raised as affirmative defense in an answer, no longer in a motion to dismiss under the new rules, while lack of cause of action, it may be raised at any time. Okay, that is the distinction, simple distinction between failure to state cause of action versus lack of cause of action. Again, failure to state, allegation in the insufficiency of allegation in the pleading or in the complaint, while lack of cause of action, insufficiency of factual basis of the action and insufficiency of evidence. Now, in the case of Tucoms Philippines Incorporated versus Philips Electronics, a 2020 case, the facts of the case, TP was appointed as distributor of appliances by Purdey in the Philippines. Now, they entered into a contract of distribution agreement. Thereafter, the contract was suddenly terminated. TP discovered that during the existence of the agreement, Purdey, in bad faith and in collusion with the new distributor, FP, has been selling to FB the products subject of the distribution agreement at a much lower price to the prejudice of TP. Thus, TP filed an action for damages and applied a TRO enjoining Purdey from proceeding with the chains of distributorship. The RTC ruled in favor of TP. On appeal, the CA reversed the RTC on the ground that the complaint's essential thrust was a prayer for damages resulting from the non-renewal of the distributorship agreement. Now, in determining whether the complaint failed to state a cause of action, the CA considered not only the complaint and its annexes, but also the evidence presented by Purdey in the hearing on TP's application for TRO. The CA Court of Appeal said that the trial court should have considered all the pleadings and evidence on record in deciding the question of whether or not the complaint states a cause of action. Now, is the Court of Appeals correct? Sabi ng Court of Appeals, the RTC should consider all the pleadings and evidence on record in deciding whether or not the complaint states a cause of action. So what the Supreme Court said? No. A cause of action is the act or omission by which a party violates a right of another. It has three constitutive elements. First, a legal right accruing to the plaintiff. a duty on the defendant's part to respect such right, and an act or omission by the defendant violative of the right of the plaintiff or constituting a breach of the obligation of defendant to the plaintiff. Now, the court said in determining the sufficiency of a cause of action, the test is whether or not admitting hypothetically the truth of the allegations of fact made in the complaint, the court may validly grant the relief prayed for in the complaint. Now, in this case, if the allegations in TV's complaint are hypothetically admitted, these acts constitute bad faith on the part of Purdey in the exercise of its rights under the distributorship agreement in violation of Article 19 of the Civil Code. Consequently, the court may validly award damages in favor of TP, as prayed for in its complaint. Now, while all the foregoing acts committed by Purdey are indeed justifiable under the terms of the distributorship agreement, the question of whether or not these acts were committed with malice or in bad faith in light of the allegations in the complaint still remains disputed. So again, failure to state a cause of action refers only to insufficiency of allegation of pleading, whereas lack of causes of action refers to insufficiency of factual basis or the action or evidence. Again, the examination is limited to the complaint in that whether it contains a verment of the three essential elements of a cause of action. So mali ang core of appeals dito. So hindi naman kailangan i-consider kagad yung evidence. So kailangan lang yung insufficiency of allegation for a cause of action, for a failure to state a cause of action. Now, joinder of causes of action. A party may in one pleading assert in the alternative or otherwise as many causes of action as he may have against an opposing party, subject to the following conditions. So, joinder of causes of action is allowed, provided these conditions must be complied. First condition, that the party joining the causes of action must comply with the rules on joinder of parties. So, joinder of parties is either permissive joinder of parties or compulsory joinder of parties. Now, permissive is when the right to relief arises out of the same transactions or series of transactions, and there is a common questions of fact or law. Whereas compulsory joinder of parties is that when the one involved is an indispensable party. So that is the distinction between a permissive and a compulsory joinder. Another condition, the joinder must not include special civil actions or actions governed by special rules. Now, what are those special civil actions? Like interpleader, declaratory relief, certiorari, prohibition mandamus, quo warranto, expropriations, foreclosure of real estate mortgage, partition, forcible entry, and unlawful detainer, and contempt. These are special civil actions. Now, what are those actions that govern by special rules, like the rules on summary procedure and rules on small claims cases? These are actions governed by special laws. Now, this cannot be joined with an ordinary civil action. Now, if the causes of action are between the same parties, but the causes of action pertain to different venues or jurisdictions, the joinder may be allowed in the RTC, provided that one of the causes of action falls within its jurisdiction and the venue lies therein. Another condition, if the claims in all the causes of action are principally for recovery of money, the aggregate amount claimed shall be the test of jurisdiction. These are the conditions where joinder of causes of action may be allowed. Now, in the case of Bello Medical Group versus Santos, a 2017 case, there the court ruled that two cases were filed by Bello Medical Group. First, the complaint for interpleader and the supplemental complaint for declaratory relief. So, complaint for interpleader and declaratory relief are both special civil actions. Now, under Rule 2, Section 5, the Rules of Court, a joinder of cause of action is allowed provided the joinder shall not include special civil action or actions governed by special rules. Assuming this case continues on as an interpleader, it cannot be joined with a supplemental complaint for declaratory relief as both are special civil actions. So hindi lang one is ordinary civil action, the other one is special civil action, but even both, if both special civil actions, it cannot be joined with the ordinary civil actions. Now, it is very important to memorize those special civil actions and actions governed by the special rules. Now, in Lahave Agricultural versus Haviliana, a 2018 case, an action for collection of sum of money may not be properly joined with the action for ejectment. Again, special civil action. The former is an ordinary civil action requiring a full-blown trial, while an action for unlawful detainer is a special civil action which requires a summary procedure. All right, now, what is the effect of failure to comply with the conditions for joinder of causes of action? So kanina sinabi natin yung mga conditions ng joinder. So what is the effect if the party failed to comply with the condition? Misjoinder of causes of action is not a ground for dismissal of an action. So sinabi natin kanina, misjoinder. So, halimbawa, joint, kagaya sa case ni Belog Medical Group. So, yung actions involve two special civil actions, interpleader and declaratory relief. So, there is a misjoinder of cause of action. But that is not a ground for the dismissal of an action. A misjoined cause of action may, on motion of a party or on the initiative of the court, be severed and proceeded with separately. So yun po ang magiging effect. On motion of the party or upon initiative by the court, it will be severed and proceeded with separately. So nakita niyo po ang picture. So like Bea and Gerard, they severed their relationship and proceeded their love life with separate partners. So parang misjoin of cause of action. The court was severed and proceeded with separately, not to dismiss the action. Now, let's move to the parties to civil actions. Who may be parties to a civil action? Now, only natural or juridical persons or entities authorized by law may be parties in a civil action under Section 1, Rule 3. Now, in Gaffney versus Butler, a 2017 case, the deceased or his estate may not be named a defendant in the present case. A deceased person does not have the capacity to be sued and may not be made a defendant in a case. Section 1, Rule 3 unequivocally states that only natural or juridical persons or entities authorized by law may be parties in a civil action. Now, in this case, petitioner filed a motion for leave to admit amended complaint for the purpose of impleading the estate or the heirs of the deceased as additional party defendant, allegedly represented by the spouse as his surviving spouse. Now, the court here ruled that the deceased or his estate may not be named as a defendant in an ordinary civil action. Now, that is the case of Gaffney versus Butler. Now, in this case of Ventura versus Militante, neither a dead person nor his estate may be a party plaintiff in a court action. Referred as ordinary civil action. A deceased person does not have such legal entity as is necessary to bring action, so much so that a motion to substitute cannot lie and should be denied by the court. Considering that capacity to be sued is a correlative of the capacity to sue, to the same extent, a decedent does not have the capacity to be sued and may not be named a party defendant in a court action. Thus, therefore, a deceased person or his estate may not be impeded as defendant in a civil action as they lack legal capacity. Note, however, that the action against the deceased or his estate must be filed as a claim against his or her estate in a proper proceeding under Rule 86, which is a special proceeding. So in the end, dito sa ordinary civil action, it can be filed as a special proceeding under Rule 86 or claims against the estate. Okay. Next. Right now. Real party in interest. Who is a real party in interest? A real party in interest is the party who stands to be benefited or injured by the judgment in the suit, or the party entitled to the avails of the suit. Now, the interest of the party here means a material interest or an interest in an issue to be affected by the judgment of the case, as distinguished from mere curiosity about the question involved. So the interest here is material interest. Now, in Saludo Jr. versus PNB, a 2018 case, the court ruled that any decision rendered against a person who is not a real party in interest in the case cannot be executed. So, sino po ba sa dalawa ang real party in interest? So, siguro po si Kylie, sapagkat he's the one, kasi siya yung sila mag-asawa, kasal sila. So, joke lang po yan. He stands to be benefited or injured. All right, now. Now, in Fernandez versus Smart Communications, a 2019 case, a corporation is an artificial being invested by law with a personality separate and distinct from its stockholders and from other corporations to which it may be connected. Inferred from a corporation's separate personality is that consent by a corporation through its representatives is not consent of the representative personally. The corporate obligations incurred through official acts of its representatives are its own. Corollarily, a stockholder, director, or representative does not become a party to a contract just because a corporation executed a contract through that stockholder, director, or representative. Now, unless there is a ground for piercing the veil of corporate fiction, a corporate director or officer cannot be a real party in interest. Because we all know settled is the rule in corporation law that a corporate director or officer is solidarily liable with the corporation only when, first, they assent to patent the unlawful acts of the corporation. Second, they acted in bad faith or with gross negligence in directing the corporate affairs. Third, they are guilty of conflict of interest to the prejudice of the corporation. And fourth, they contractually agreed to hold themselves personally and solidarily liable with the corporation, or by specific provision of law, they are personally liable for corporate action. So in this case, so Fernandez, the corporate director officer here cannot be held solidarily liable with the corporation. So thus they cannot be the real party in interest. Okay, next. In the case of RG Cabrera Corporation versus DPWH and Commission on Audit, a 2021 case, the COA found that RGCCI excuse me, has no juridical personality since the SEC certified that the records do not show the registration of RGCCI as a corporation. Moreover, there is no proof that RG Cabrera Construction Incorporated, which is the name of the corporation that transacted with the DPWH, is one and the same with RGCCI. The COA decided to deny the money claim. It found that RGCCI has no lucus standi to file the petition. Now, The court ruled that it is clear that RGCCI, RG Cabrera Construction and Supplies, and RG Cabrera Senior Tracking Corporation are one and the same entity and therefore cannot be considered as a real party in interest who stands to be benefited or injured by the judgment in the suit. First, the names of the corporation stated contain the name of the family patriarch, Ruben G. Cabrera. Second, all of the corporations use the Cabrera ancestral house at LNM subdivision, Guagua, Pampanga as their address. Lastly, the corporations are composed of the same family members. In sum, it is immaterial as to under which name the DPWH directs its payment because ultimately the payment will end in the hands of the performer of the services under the contract, thus extinguishing the obligation. So, a real party in interest is the one who stands to be benefited or injured by the judgment in the suit. Now, indispensable party. Who is an indispensable party? An indispensable party is a party in interest without whom no final determination may be had of an action. Now, an indispensable party is one who has an interest in the controversy that a final decree would necessarily affect his or her rights, such that the courts cannot proceed without his or her presence in the actions. Now, on the other hand, a party is not considered as an indispensable party if his interest in the controversy is distinct and divisible from the interest of the other parties and will not necessitate or it will not necessarily be prejudiced by a judgment. Now, in heirs of Dinglasan versus Ayala Corporation, a 2019 case, the court ruled that it is settled that the joinder of all indispensable parties is required under any and all conditions, their presence being a sine qua non of the exercise of judicial power. The absence of an indispensable party renders all subsequent actions of the court null and void for want of authority to act, not only as to the absent parties, but even as to those present. So, joinder of indispensable parts is required under any and all conditions. So, an indispensable party must be joined. Now, in this case of Asian Terminal versus Padoson Stainless, the 2018 case, the court ruled that the ultimate relief sought by ATI, Asian Terminal, in its complaint for a sum of money with damages is the recovery of the storage fees from Paduson, which arose from the contract of service which they have validly entered into. BOC was never privy. The Bureau of Customs was never privy to this contract. It was Padoson who engaged the Asian Terminal Storage Services, and it was Padoson who benefited from ATI storage services. Now, the Bureau of Customs' interest over shipment, which is the subject matter of the customs case, is merely to collect from Padoson its tax dues. It is separate and distinct from the claim of ATI in its complaint for a sum of money, which is to demand from Padoson the payment of storage fees based on their contract of service. BOC's interest over shipments is not inextricably intertwined with ATI's collection suit against Padoson, so as to require its legal presence as a party to the proceeding. In other words, complete relief can still be afforded to ATI without the presence of the BOC, in the case can still be decided on the merits without prejudicing BOC's rights. Thus, the BOC is not an indispensable party to the complaint for a sum of money. Kasi sinabi natin kanina, if it merely, if the claim is merely separate, divisible, or distinct from the claim of the other party, then he's not an indispensable party. Again, a party is not indispensable if this interest in the controversy is distinct and divisible from the interest of the other parties. So in this case, BOC is not an indispensable party. Now, however, settled is the rule that non-joinder of indispensable parties is not a ground for dismissal of an action. Now, the remedy is to implead the non-party claimed to be indispensable. Parties may be added by order of the court, on motion of the party, or on its own initiative at any stage of the action and or at such times as are just as held in the case of Plasabas versus Court of Appeals and Dinglasan versus Ayala Corporation. So again, non-joinder of indispensable parties is not a ground for a dismissal of an action. Now, in the case of Tesla versus Abragar 2021 case, the joinder of all indispensable parties is a condition sine qua non for the exercise of judicial power. While the failure to implead an indispensable party is not per se a ground for dismissal of an action, considering that said party may still be added by order of the court, on motion of the party, or on its own initiative at any stage of the action and or such time as are just. It remains essential, as it is jurisdictional, that any indispensable party be impeded in the proceedings before the court renders judgment. Now, the absence of an indispensable party renders all subsequent actions of the court null and void for want of authority to act not only as to the absent parties, but even as to those present. Thus, the failure to impede Testa in this case and the other parties to the MOA renders the July 30, 2004 decision of the labor arbiter and writ of execution null and void for want of authority, which may be attacked in any way at any time, even when no appeal is taken. It is immaterial that Testa filed the appeal memorandum in intervention after the labor arbiter judgment became allegedly final and executory, since a judgment void ab initio is non-existent and thus cannot acquire finality. Now, that is the joinder of that is the indispensable parties. Now, let's move to pleadings in general under Rule 6. Pleadings. Pleadings are written statements of the respective claims and defenses of the parties submitted to the court for appropriate judgment. Now, what are the pleadings allowed? First, initiatory pleading, complaint. We have this counterclaim, cross-claim, third-party complaint, complaint in intervention, answer and reply. Now, contents of a pleading. So ano po ba nakalagay sa pleading? So since nag-file na tayo ng complaint, so pag-usapan natin yung complaint. What a complaint or the pleading in general must contain. Number 1, caption. Name the court, title of the action, and docket number. Number 2, the body. So dito po nagkaroon na ng amendment. So may mga inidagdag. Now, the body must contain first, designation of the pleadings. Second, the allegations of the parties' claims or defenses. Third, relief prayed for. Now, specific relief sought and a general prayer for such further or other relief as may be deemed just or equitable. So, pwede rin po yun. So, general prayer. Letter D, date. Letter E, ito po yung nadagdag ng amendments, ng new rules. Name of witnesses who will be presented to prove a party's claim or defenses. Another, yung letter F, summary of the witnesses' intended testimonies, provided the judicial affidavits of said witnesses shall be attached to the pleading and form an integral part thereof. Now, before, yung judicial affidavit is required during the pre-trial and trial. But now, upon filing the complaint, the judicial affidavit of the intended witnesses shall be included, shall be attached. Now, as a rule, only witness or witnesses named in the pleadings with judicial affidavits attached to the pleading shall be presented during trial. So yun lang pwede, except if the party presents a meritorious reason for the admission of additional witnesses. Kahit hindi siya nakalagay dun sa, naka-name dun sa pleadings or naka-attach ang kanyang judicial affidavit. Now, in other words, an additional witness may be presented during the trial even if such witness was not named in the pleading nor his or her judicial affidavit attached to the pleadings, as long as the party present a meritorious reason, of course, to be approved by the court. Now, with the amendment, the rules require that every pleading shall contain a direct statement of ultimate facts and now evidentiary facts. So dalawa na, before ultimate facts lang ang inaalin sa pleading, sa complaint. Now ngayon, meron na evidentiary facts. So ultimate facts and evidentiary facts. So that is the new amendments. And the last, the pleading must contain, the body must contain the documentary and object evidence in support of the allegations contained in the pleading. So hindi lang testimonial evidence, pati documentary and object evidence must be stated in the complaint. So documentary, walang problema sapagkat i-attach na yung original or pa-certified true copy kung meron. Pag object evidence, para mahirap yun. Pero it will just manifest to the court na may object evidence to be presented. And then the court may conduct an ocular inspection. So that is the body of the complaint. So naidagdag po yung letter EFG before A to D lang. Ngayon nadagdag na. So again, pag nag-file ng complaint, naka-state na yung ultimate facts and evidentiary facts. Okay, next. Contents of a pleading, continuation. Another signature and address signed by the party or counsel representing him or her. Now, the signature of counsel constitutes a certification that the counsel has first read the pleading and document and that it is not presented for improper purpose. And third, the claims or defenses has legal basis in law and jurisprudence and that the factual contentions have evidentiary support. Kasi kailangan ng may evidentiary facts na. So it must contain an evidentiary support. And the denial of factual contentions are warranted on the evidence. So that represents the signature of the counsel. Now, next, another is verification. As a rule, pleadings need not be under oath or verified, except when specifically required by law or rule. Now, example of a pleadings required to be verified, yung petition for relief from judgment under Rule 38, petition for review on certiorari under Rule 45, petition for certiorari, a special civil action under Rule 65, petition for annulment of judgment under Rule 47. Now, what is the effect if the pleading required to be verified is not verified, lacks verification? It shall be treated as an unsigned pleading. So, yun lang po ang effect. Number 5, requirements. The pleading must contain a certification against forum shopping. Now, certification against forum shopping is a certification of the plaintiff or principal party that first, he or she has not commenced any action or filed any claim involving the same issues in any court, tribunal, or quasi-judicial agency. And to the best of his or her knowledge, no such other action or claim is pending therein. Second, if there is such other pending action or claim, a complete statement of the present status thereof. And third, if he or she should thereafter learn that the same or similar action or claim has been filed or is pending, he or she shall report that fact within 5 calendar days thereof, within 5 calendar days from knowledge to the court. Now, what this the effects on certification against forum shopping? First, failure to comply with the requirements of certification, dismissal without prejudice, unless otherwise provided upon motion and hearing. Second, submission of false certification and non-compliance with any of the undertakings, indirect contempt without prejudice to administrative and criminal actions. Now, if the acts constitute or constitutive of willful and deliberate forum shopping, it will cause for a summary dismissal with prejudice, direct contempt, and administrative sanctions. Now, that is the effect of certification against forum shopping. Okay, next. Verification and certification of non-forum shopping. So kalimitan sa PDs, pinagsasama yung verification and certification of non-forum shopping. In Alters versus Impleo, a 2008 case, jurisprudential rules governing the submission and contents of the verification and certification of non-forum shopping. So the Supreme Court provided rules in the submission and contents of the verification and certification of non-forum shopping. First, a distinction must be made between non-compliance with the requirement on or submission of defective verification, and on the other hand, the non-compliance with the requirement on or submission of defective certification against forum shopping. So a distinction must be made with a defective verification or a defective certification against forum shopping. Second, as to verification, non-compliance therewith or defect therein does not necessarily render the pleading fatally defective. In this instance, the court may order its submission or correction or act on the pleading if the attending circumstances are such that strict compliance with the rule may be dispensed with, in order that the ends of justice may be severed thereby. So in several cases, the court relaxed this rule. Third, verification is deemed substantially complied with when one who has ample knowledge to swear to the truth of the allegations in the complaint or petition signs the verification, and when matters alleged in the petition have been made in good faith or are true and correct. Another rules. As to certification against forum shopping, non-compliance therewith or a defect therein, unlike in verification, is generally not curable by its subsequent submission or correction thereof. Kasi sa verification, pwedeng ma-cure by subsequent submission or correction. But here, in certification against forum shopping, it's a general rule, it cannot be cured by subsequent submission or correction unless there is a need to relax the rule on the ground of substantial compliance or presence of special circumstances or compelling reasons. So in effect, ganun din, pwedeng i-relax ng court if there is substantial compliance or special circumstances or compelling reasons. Number 5, the certification against forum shopping must be signed by all the plaintiffs or petitioners in a case. Otherwise, those who did not sign will be dropped as parties to the case. Now, in several cases, the court ruled that under reasonable or justifiable circumstances, however, as when all the plaintiffs or petitioners share a common interest and invoke a common cause of action or defense, the signature of only one of them in the certification against forum shopping substantially comply with the rule. So pag nakitang may common cause of action, common interest, so yung one signature will be suffice. Next, and finally, the certification against forum shopping must be executed by the party pleader, not by his counsel. So ang certification ay nag-execute ay ang party pleader, not the counsel. Now, in the case of digital employees union versus digital telecoms, the court ruled that if, however, for reasonable or justifiable reasons, the party pleader is unable to sign, he must simply execute a special power of attorney designating his counsel of record to sign on his behalf. As a rule, yung party pleader, but if there is special power of attorney, pwede. The counsel may sign the certification against forum shopping. Okay, now let's proceed to filing of answer. Filing of answer. So kanina nag-file ng complaint, yung plaintiff, then yung defendant will file his answer. Answer, a pleading in which a defending party sets forth his or her defenses. Defenses are negative defense or affirmative defense. A negative defense is the specific denial of the material facts alleged in the pleading of the claimant essential to his or her causes of action, while affirmative defense is an allegation of a new matter, which, while hypothetically admitting the material allegations in the pleading of the claimant, would nevertheless prevent or bar recovery by him or her. So defenses can either be negative defense or affirmative defense. Now, these are the affirmative defenses under the rules. So number one, the court has no jurisdiction over the subject matter of the claim, subject matter jurisdiction. Number two, that there's another action pending between the same parties for the same cause, litis pendentia. Third, that the cause of action is barred by a prior judgment, res judicata, or a statute of limitations prescription. Fourth, that the court has no jurisdiction over the person of the defending party. Fifth, that the venue is improperly laid or improper venue. Number six, that the plaintiff has no legal capacity to sue. Seven, that the pleading asserting the claim states no cause of action. Number eight, that the claim or demand set forth in the plaintiff's pleading has been paid, waived, abandoned, or otherwise extinguished. Number nine, that the claim on which the action is founded is unenforceable under the statute of frauds. 10, that a condition precedent for filing the claim has not been complied with. And number 11, fraud. And another one, illegality. 13, estoppel, former recovery, discharge in bankruptcy, and any other matter by way of confession and avoidance. Na mamaya titingnan natin pagdating natin sa Rule 6, Rule 15, kung ito ba ay pwedeng i-raise as a motion to dismiss or just merely as an affirmative defense. Now, however, if the affirmative defense is denied, however, itong mga affirmative defense na to ay denied, the defendant is not allowed to file a motion for reconsideration or petition for certiorari, prohibition, or mandamus. The only thing he can do is to raise the matters on appeal after a judgment on the merits. So ngayon, specific na po yan sa new rules that pag na-denied ang affirmative defense, hindi ka pwede mag-file ng MR or petition for certiorari, prohibition, or mandamus. So, hintayin mo na lang, i-decide yan on the merits, then sa appeal, pwede mo siyang erase ulit. Dismissal with prejudice of affirmative defenses. So, subject to the right of appeal, an order granting an affirmative defense that the cause of action is barred by a prior judgment or by the statute of limitations, that the claim or demand set forth in the plaintiff's pleading has been paid, waived, abandoned, or otherwise extinguished, or that the claim on which the action is founded is unenforceable under the provisions of the statute of fraud shall bar the refiling of the same action or claim. So ito lang yung tatlong affirmative defenses na will bar the refiling of the same action or claim. Okay, that is the new rules under Section 13 of Rule 15. Ay, ganda nga kasi may... Okay, next. Counterclaim. So kanina nag-file siya ng answer. So ang defendant kasi, pwede rin siyang may counterclaim sa plaintiff. A counterclaim is any claim which a defending party may have against an opposing party. Now, counterclaim can either be compulsory counterclaim or permissive counterclaim. What are the distinction? What is the distinction of compulsory counterclaim and permissive counterclaim? First, compulsory counterclaim if it arises out of or is connected with a transaction or occurrence constituting the subject matter of the opposing party's claims. Whereas a permissive counterclaim if it does not arise out of or is not necessarily connected with the subject matter of the opposing party's claims. It is essentially an independent claim that may be filed separately in another case. Compulsory counterclaim is barred if not set up in the action, whereas permissive counterclaim is not barred even if it is not set up in the action. In compulsory counterclaim, payment of filing fees is suspended. As of now, suspended pa po ang filing fees sa compulsory counterclaim. Whereas in permissive counterclaim, payment of filing fees is required. The RTC. Now, in compulsory counterclaim, it need not be accompanied by certification against forum shopping. But in a permissive counterclaim, it must be accompanied by certification against forum shopping. In compulsory counterclaim, as a rule, need not be answered, whereas a permissive counterclaim need to be answered, otherwise the plaintiff could be declared in default. So these are the distinction of compulsory counterclaim and permissive counterclaim. Now, in Villanueva-Ong versus Enrile, a 2017 case, jurisprudence has laid down tests in order to determine the nature of a counterclaim. First question, are the issues of fact and law raised by the claim and the counterclaim largely the same? So, same ba ang issue ng fact and law? Number 2 question, would res judicata bar a subsequent suit on defendant's claims absent the compulsory counterclaim rule? Third, will substantially the same evidence support or refute plaintiff's claim as well as the defendant's counterclaim? And third and fourth, is there any logical relation between the claim and the counterclaim? A positive answer to all 4 questions would indicate that the counterclaim is compulsory. Now, this is the test whether a counterclaim is compulsory or permissive. All right. Now, in Perkin-Elmer versus Daquila Trading, a 2007 case, a counterclaim purely for damages and attorney's fees by reason of the unfounded suit has long been settled as falling under the classification of compulsory counterclaim, and it must be pleaded in the same action, otherwise it is barred. In Villanueva-Ong versus Enrile, the 2017 case, the court's ruling in Korea Technologies versus Lerma 2008 case, which held that effective August 16, 2004, under Section 7, Rule 141, as amended by Administrative Matter Number 04204 SC, docket fees are now required to be paid in compulsory counterclaim or cross claims. Note must be taken of OCA Circular Number 96/2009 entitled Docket Fees for Compulsory Counterclaims, dated August 13, 2009, where it was clarified that the rule on imposition of filing fees on compulsory counterclaims has been suspended. Such suspension remains in force up to this day. So payment for a compulsory counterclaim is suspended. Filing fees. Okay, now reply. Kanina nag-file ng complaint, nag-file ng answer, din counterclaim. Then yung plaintiff ulit, pwede ulit mag-file ng reply sa answer ng defendant. A pleading, the office or function of which is to deny or allege facts in denial or avoidance of new matters alleged in or relating to actionable document. Now, the actionable document is a written instrument or document on which an action or defense is based upon, right? Now, under the new rules, the plaintiff may file a reply only if the defending party attaches an actionable document to his or her answer. So, in the reply of the plaintiff must specifically deny under oath the genuineness and due execution of that actionable document and set forth what he or she claims to be the facts otherwise. Because otherwise, the genuineness and due execution of the document will be deemed admitted. However, the requirement of specific denial under oath does not apply in two instances. First, when the adverse party does not appear to be a party to the instrument, so hindi siya party sa contract, or during this mode of discovery, when the compliance with an order for an inspection of the original instrument is refused. Again, the plaintiff may file a reply only if the defending party attaches an actionable document. Now, question, but suppose the plaintiff wants to interpose a claims arising out of new matters so alleged. Can he file a reply? No. Such claim shall be set forth in an amended or supplemental pleading. So the plaintiff can only file a reply only if the defending party attaches an actionable document. So that is the new rule now. Kasi nga kanina, di ba, nabanggit natin na di lang ultimate facts ang kailangan ilagay, pati rin evidentiary facts. So ganun din sa pag-file ng reply. If the defending party attaches an actionable document, then that is the time that the reply can be filed by the plaintiff. Now, rejoinder. So yung reply, pag-file ng plaintiff ng reply, so yung defendant, pwede rin mag-file ng rejoinder. So kontra. Sagot. Now, in the event of an actionable document attached to the reply, the defendant may file a rejoinder if the same is based solely on an actionable document. So ang defendant, hindi basta-basta pwede mag-file ng rejoinder. If yung actionable document, if the reply, walang actionable document. So, actionable document to actionable document sa reply and sa rejoinder. All right. Okay, next. So, okay, now we'll proceed to filing and service of pleadings. So, kanina okay na tayo dun sa ano. We'll move to filing and service of pleadings. Filing and service of pleadings under Rule 13. So, ito na po ang modes of filing and date of filing. Filing of pleadings, motions, and other court submission. The modes of filing now is by submitting personally the original thereof plainly indicated as such to the court. A pleading file can be filed also by sending them by registered mail, by accredited courier, and or by transmitting them by electronic mail or other electronic means as may be authorized by the court in places where the court is electronically equipped. Now, the date of filing, if the pleadings was served personally, is the date endorsed on the pleading by the clerk of court. The date of filing in case of registered mail is the date of mailing. The date of filing of accredited courier is the date of mailing. Same with registered mail. The date of filing, if the mode of service is electronic mail or other electronic means, is the date of electronic transmission. So, dyan nagkakaiba-iba ang determination of date of filing. Next, modes of service of pleadings, motions, notices, and other court submissions. Personal service, registered mail, accredited courier, electronic mail, facsimile transmission, or other electronic means as may be authorized by the court. Facsimile transmission, naulit na, as provided for in international conventions to which the Philippines is a party. Now, these are the modes of service of pleadings, motion, notice, and other court submissions. Now, modes of service of pleadings, motion, notice, and other court submission, and vis-a-vis completeness of service. Now, If the mode of service is through personal service, the service is complete upon actual delivery. Now, in case of registered mail or ordinary mail, so allowed pa rin ang ordinary mail if no registered service available in the locality. But as a rule, registered mail. Kasi may mga locality wala pang registered mail, so ordinary mail, so pwede pa rin. Now, if the mode of service is through registered mail or ordinary mail, the service is complete upon actual receipt by the addressee or after 5 calendar days from the date he or she received the first notice of the postmaster, whichever date is earlier. Ito yung tinatawag na constructive delivery. So upon actual receipt, actual service, and constructive delivery, yung 5 calendar days from the date he received the first notice of the postmaster. Now, in case of ordinary mail, the service is complete upon the expiration of 10 calendar days after mailing, unless the court otherwise provides. Now, in case of accredited courier, the service is complete upon actual receipt by the addressee or after at least 2 attempts to deliver by the courier service or upon the expiration of 5 calendar days after the first attempt to deliver, whichever is earlier. So, next, if the modes of service is through electronic mail or other electronic means, the service is complete at the time of the electronic transmission of the document or when available at the time that the electronic notification of service of the document is sent. Now, if through facsimile transmission, the service is complete upon receipt by the other party as indicated in the facsimile transmission printout. Now, if as provided for international conventions to which the Philippines is a party, wala pang rule na ilalabas, or kung meron man, so hindi pa natin, I am not aware yet pa. Okay, now that is the modes of service vis-a-vis the completeness of service. Now, pleadings, motion, notice, orders, court submission. This is the matrix of personal, registered mail, accredited courier, email or electronic means, or by publication. Now, pleadings, motions, notices, other court submissions, and court-issued orders and other documents can be served through personal service, yes, through registered mail, through accredited courier, through email, but not publications. In case of initiatory pleadings and initial responsive pleadings, such as an answer, it should be served through personal service and registered mail when allowed, but not by accredited courier. Also, email is not allowed unless express permission is granted by the court, but not by publication. Subpoena, protection orders, and writs, it can be served through personal service. It can also be served through registered mail, provided it is allowed by the court, but it cannot be served through accredited courier and through email or other electronic means, unless express permission is granted by the court, but not by publication. Number 4, appendices and exhibits to motions or other documents that are not readily amenable to electronic scanning may, at the option of the party filing such, be filed and served conventionally. So it can be filed through personal service, yes. It can also be served through registered mail when allowed, but not by accredited courier, and also not by email or electronic means, unless express permission is granted by the court, but not by publications. Sealed and confidential documents or records, it can be served through personal service or filed through personal service. It can also be served and filed through registered mail, provided it is allowed, but it is not allowed through accredited courier and through email or other electronic means, except unless express permission is granted by the court, but not by publication. So judgments, final orders, or resolution, it can be served through personal service, through registered mail, through private courier upon ex parte motion at the expense of the party. Email, hindi pwede. Publication, yes. Provided a party previously summoned by publication failed to appear. So before na-summon na siya through publication, hindi siya nag-appear, this time pwede pagpadala sa kanya through publication pa rin. Kasi nga, nung hindi nga siya serve sa kanya ng personally by registered mail, nag-resort to publication. With more reason dito sa judgment or orders. Dapat publication din. All right, now, in Barroso versus COA, a 2021 case, service and filing of pleadings via private courier should be reckoned from the date of mailing when said private courier is accredited by the courts. So, kailangan accredited. So, iba sa Supreme Court, meron silang accreditation ng courier. Maglalabas sila ng list ng mga accredited courier. So, napaka-importante whether that courier is accredited or not. Otherwise, the pre-amendment jurisprudential doctrine will govern. That is, it will be considered similar to filing via ordinary mail where the date of actual receipt is deemed the date of filing, albeit it was posted much earlier. So, pag ang private courier is not accredited by the Supreme Court, then the rule on ordinary mail will govern. That is the date of actual receipt, not the date of filing, is deemed the date of filing. Now, under Rule 13, Section 14 of the new rules, initiatory pleadings such as the present petition for certiorari should be filed personally or via registered mail. The provision does not allow its filing via private courier, regardless of accreditation. Under such circumstance, the petition should be treated as if filed via ordinary mail. Consequently, the date when the court actually received a copy of the present petition shall be deemed the date of filing, not the date of mailing. So, pag basta initiatory pleading, initiatory pleading, pwede lang yan, personal service or registered mail. So, yan pwede through private courier. So, whether that a private courier is accredited or not, it is immaterial. So, regardless whether accredited or not, as long provided it is an initiatory pleadings. Okay, now let's move to summons. Now, it must be recalled that the court acquires jurisdiction over the person of the defendant upon valid service of summons. So there must be a valid service of summons in order the court can acquire jurisdiction over the person of the defendant. Also, the voluntary appearance of the defendant, either by filing a motion to dismiss or by filing an answer, shall be equivalent to service of summons. So, napag-usapan natin yan kanina. Now, who may serve summons? First, sheriff, his or her deputy. Second, other proper court officer. Now, itong third and fourth, ito yung additional ng bagong rules. Before, sheriff or deputy lang and the other proper court officer. They are those designated as process server. Ngayon, kasama na rin yung plaintiff and counsel. Now, in case of failure of service by them, by the sheriff, by his deputy, or by the proper court officer, the court may authorize the plaintiff to serve the summons together with the sheriff. So, kasama yung sheriff. Another is that where the summons is improperly served and a lawyer makes a special appearance on behalf of the defendant, among others questioning the validity of the service summons, the counsel shall be deputized by the court to serve summons on his or her client. So pwede deputize ang counsel pag nag-appear. So these are the persons who are authorized as a process server in serving summons. Instances where plaintiff is authorized to serve summons. There are two instances. In case of failure of service of summons by the sheriff, his or her deputy, or other proper court officer, or in cases where summons is to be served outside the judicial region of the court. These are the two instances where the plaintiff may be authorized to serve summons. So failure service of summons. sasama ng sheriff, and in case the summons is to be served outside the judicial region of the court. Plaintiff's misrepresentation of service of summons. What if the plaintiff misrepresent na, na-serve ko na po ang summons? What will happen? The case shall be dismissed with prejudice. The proceeding shall be nullified and the plaintiff shall be meted appropriate sanctions. So, dapat lang kasi baka sabihin, ay, na-serve ko na po, pero hindi naman pala. All right. Now, modes of service of summons. Remember, distinction should be made between service of pleadings, service of notices of judgment, order, resolution, and service of summons. Personal service of summons. Now, this is the preferred mode in service of summons. By handing a copy to the defendant in person, if the defendant refused to receive in sign, by leaving the summons within the view and in his presence, even by tendering of summons. So, kailangan na within the view and in his presence. Now, if personal service cannot be made, the process server may resort to substituted service of summons. Now, if for justifiable causes, the defendant cannot be served personally after at least or after at least 3 attempts on 2 different dates, servers may be affected by substituted service of summons. Now, paano po ba ito ginagawa? First, by leaving copies at the defendant's residence to a person at least 18 years of age and of sufficient discretion residing therein. Or by leaving copies at the defendant's office or regular place of business with some competent person in charge thereof. By leaving copies, if refused entry upon making his or her authority and purpose with any of the officers of the Homeowners Association or Condominium Corporation or its chief security officer in charge of the community or building. I remember there's a one case here na question nyo yung summons kasi hindi pinapasok sa condominium pero may instruction sa security guard na huwag tanggapin yung summons. Pero sabi ng court there is a valid substituted service of summons. Kasi kahit hindi tinanggap ng security guard, pero may instruction kasi siya na huwag tanggapin. So, in effect, there's a valid service of summons. Kahit hindi tinanggap. Kasi may specific instruction na huwag tanggapin. So, may isang case po dyan na gano'n na nangyari. Now, under the new rules, pag sa corporate, pag sa condominium and subdivision, so pwede serve sa officers of the homeowners association or the condominium corporation or yung chief security officer in charge of the community or the building or the condo building. Next, by sending an email to defendant's electronic email address if allowed by the court, because there are lugar na mga court na mga hindi pa equipped ng mahina pa mga internet. So pag allowed lang ng court. Now, summons by publication. When the defendant is a foreign private juridical entity which is not registered in the Philippines or has no resident agent but has transacted or is doing business. So pwede yan by summons by publications. Another is when the defendant is designated as a known owner or the like, or whether his or her whereabouts are unknown and cannot be ascertained by diligent inquiry within 90 calendar days from the commencement of the action, summons by publication is allowed. Also, when the defendant does not reside and is not found in the Philippines, and the action affects the personal status of the plaintiff, or relates to or the subject of which is property within the Philippines, in which the defendant has or claims a lien or interest, actual or contingent, or in which the relief demanded consists wholly or in part in excluding the defendant from any interest therein, or the property of the defendant has been attached within the Philippines. Ito yung extraterritorial service. Ay, nako, patay. And another is when the defendant is temporarily out of the Philippines. Summons may be made by publication. Now, extraterritorial service of summons. Yung nabanggit natin kanina yung letter C. So, when can it be availed? First, when the defendant is a non-resident and is not found in the Philippines. And the action first affects the personal status of the plaintiff and it relates to property within the Philippines in which the defendant has or has claimed an interest or the relief demanded which consists of excluding the defendant from any interest therein or the property of the defendant has been attached within the Philippines. And the other one is service inconsistent with the international conventions. Service upon domestic private juridical entity. You know, in a civil action, usual naman a defendant, ang defendant is either a natural person or a juridical person. Now, with the defendant is a corporation, partnership, or association with juridical personality, service may be made on the following: president, managing partner, general manager, corporate secretary, treasurer, in-house counsel of the corporation wherever they may be found, or in their absence or unavailability, their secretaries, or if the service cannot be made upon any of the foregoing persons, upon the person who customarily receives the correspondence for the defendant at its principal office. Before, hanggang 5 lang ang pwede: president, manager, general manager, corporate treasurer, at in-house counsel. Ngayon, dito sa new rules, na-qualify na yung in-house counsel of the corporation wherever they be found. And of course, the secretaries and those persons who customarily receives the correspondence. So ito yung mga dinagdag sa bagong amendments. Now, under the old rule, it is already settled that service on a domestic juridical entity must be made only on the person expressly listed in section 11, Rule 14 of the 1997. Now, if the service made upon the person other than those officers, the same is invalid. So maraming jurisprudence yan, maraming decision dyan. This jurisprudence must be applied also in the present rule. Kasi dinagdagan lang naman ng mga persons who are authorized to receive summons for the corporation. But again, the principle in several cases, the Cyber Report remains good law. Okay. All right, now, substituted service of summons. Strict compliance with the prescribed requirements. In substituted service, the sheriff must strictly comply with the prescribed requirements as held in the Manoto case. Ito yung Manoto case to. First, impossibility of prompt personal service. The party relying on substituted service or the sheriff must show that defendant cannot be served promptly or there is impossibility of prompt service. Okay. Now, in Manotok versus CA 2006, for substituted service of summons to be available, there must be several attempts by the sheriff to personally serve the summons within a reasonable period of 1 month, 30 calendar days, which eventually resulted in failure to prove impossibility of prompt service. Several attempts mean at least 3 tries, preferably on at least 2 different dates. So under the old rule, nakalagay lang sa rules, the sheriff shall serve within a reasonable time. So maraming decision nagkaiba-iba, sabi 7 days, reasonable daw, 15 days, reasonable daw, 30 days, reasonable daw. So maraming decision na dinetermine yung kung reasonable ito or hindi. So under the new rules, fixed na. It must be served at least 3 attempts on 2 different dates. So yan ang bagong rules. So inadapt ang Manotok versus CA sa new rules. Okay? That is the requirements. First, the impossibility of prompt personal service. Another requirement is specific details in the return. The sheriff must describe in the return of summons the facts and circumstances surrounding the attempted personal service. In other words, the efforts made to find the defendant and the reasons behind the failure must be clearly narrated in detail in the return or the sheriff's return. In Manotok versus CA, the date and time of the attempts on personal service the inquiries made to locate the defendant, the names of the occupants of the alleged residence or house of defendant, and all other acts done through though putative to serve the summons on defendant must be specified in the return to justify substituted service. So dito lang sa daytime, inquiries made to locate, name of the occupants, and other occupants. This will show the efforts on the part of the sheriff to find the defendant. Kaya kailangan specific details in the return, the sheriff's return. Okay, now, another requirements, a person of suitable age and discretion. If the substitute service will be effected at defendant's house or residence, it should be left with a person of at least 18 years of age and of sufficient discretion residing therein. Now, a competent person in charge in case of office, if the substituted service will be effected at the defendant's office or regular place of business, it should be served with some competent person in charge thereof. A competent person is one who customarily receives correspondences for the defendant. Now, in Express Padala versus Ocampon, 2017 case, dwelling house or residence refers to the place where the person named in the summons is living at the time when the service is made, even though he may be temporarily out of the country at the time. Similarly, the terms office or regular place of business refer to the office or place of business of defendant at the time of service. And another requirements, an authorized person in charge to conform to the amendments of the rule. Pero dun sa Manotok, hindi pa lang, 4 lang. So dito dinagdag natin kasi may bagong amendments. If refused entry upon making his or her authority and purpose known with any of the officers of the homeowners association or condominium corporation or is chief security officer in charge of the community or the building where the defendant may be found. So service to this authorized person must be made in proper order. And number 6, if through electronic mail, if allowed by the court, by sending an electronic mail to the defendant's electronic email address. So pag allowed lang ng court, pag hindi pwede mag-send email. Okay, next. Voluntary appearance. So, na-discuss na natin to kanina. So, the defendant's voluntary appearance in the action shall be equivalent to service of summons. As a rule now, even if there is an improper service of summons, the voluntary appearance of the defendant, whether with qualifications or without qualifications, is equivalent to service of summons. In other words, the invalidity of the service of summons is cured by the voluntary appearance of the defendant in court and his or her submission to the court's authority. Now, the inclusion in a motion to dismiss of other grounds aside from lack of jurisdiction over the person of the defendant shall be deemed a voluntary appearance. Under the old rule, the inclusion in a motion to dismiss and other ground shall not be deemed a voluntary appearance. Ngayon, sinabi ng deemed voluntary appearance. But before, hindi daw yun voluntary appearance. So ngayon, the rule now as stands. So this, ibig sabihin, whether the appearance with qualification or without qualifications, the inclusion in a motion to dismiss of other grounds assigned for lack of jurisdiction over the person shall be deemed a voluntary appearance. All right. Now, time check po tayo is 11:31. Enough hour na po tayo. So again, can we request for another short break, 2-minute break? Madam Host, can we have a break? All right, are we? Now let's resume. Okay, wait for a minute. Okay. Now we're done with summons. Now we're going to proceed with motions under Rule 15. Motions under Rule 15. Now, there are two motions involved in Rule 15, litigious motions and non-litigious motions. Litigious motions are motions which the court may not act upon without prejudicing the rights of adverse parties. Whereas a non-litigious motions are motions which the court may act upon without prejudicing the rights of adverse parties. Now, under the rules, litigious motions and non-litigious motions are as follows. Litigious motions, first, motion for bill of particulars, motion to dismiss, motion for new trial, motion for reconsideration, motion for execution pending appeal, motion to amend after a responsive pleading has been filed, motion to cancel statutory lien, motion for an order to break in or for a writ of demolition, sa execution po yan, motion for intervention, motion for judgment on the pleadings, and motion for summary judgment. Demurrer to evidence, motion to declare defendant in default, and other similar motion. While non-litigious motions are motion for the issuance of an alias summons, motion for extension to file answer, motion for postponement, motion for the issuance of writ of execution, motion for the issuance of an alias writ of execution, motion for the issuance of a writ of possession, motion for the issuance of an order directing the sheriff to execute the final certificate of sale, and other similar motions. Now, these non-litigious motions do not require hearing, because any resolution of the court in these motions will not prejudice the rights of the adverse party, even if it is favorable to the movant. So, hindi na kailangan ng hearing, unlike in litigious motions. Now, litigious motions, all motions shall be served to the other party. The opposing party shall file his or her opposition within 5 calendar days from receipt. The motion shall be resolved within 15 calendar days from its receipt of the opposition, or upon expiration of the period to file such opposition. The court may set for a hearing. In non-litigious motions, all motions shall not be set for hearing and shall be resolved by the court within 5 calendar days from receipt thereof. So that is how litigious motions and non-litigious motions were handled. Now let's proceed to prohibited motions under Rule 15. First, motion to dismiss on the following grounds. First, that the court has no jurisdiction over the person of the defending party. So prohibited na po to. Second, that the venue is improperly laid or improper venue. Third, that the plaintiff has no legal capacity to sue. Fourth, that the pleading asserting the claim states no cause of action. Fifth, that the claim or demand set forth in the plaintiff's pleading has been paid, waived, abandoned, or otherwise extinguished. Next, that the claim on which the action is founded is unenforceable under the statute of frauds, and that a condition precedent for filing the claims has not been complied with. Another prohibited motions, motion to hear affirmative defenses, motion for reconsideration of the court's action on the affirmative defenses, motion to suspend proceedings without a temporary restraining order or injunction issued by a higher court. Fifth, motion for extension of time to file pleadings, affidavits, or any other papers except a motion for extension to file an answer, because it is extendable by, it may be granted on a meritorious ground and can be extended with a period of not more than 30 calendar days. Motion for postponement intended for delay, except if it is based on acts of God, force majeure, or physical inability of the witness to appear and testify. Now, these are the prohibited motions. Now, motion to dismiss under Rule 16. Yung luma to. Now, what happened to Rule 16? Parang si Thanos nawala. Pero under the new rules, the provisions of Rule 16 on motion to dismiss are either deleted or transposed. So in effect, na-delete na siya, pero napunta yung ibang provisions, napunta sa ibang rules, sa Rule 15, sa Rule 6, so kumalat. Pero sa rules, nawala na siya. Now this is the matrix and summary of the grounds under the old rules and the new rules. So under the old rules, what are the motion to dismiss and what are the affirmative defenses? And under the new rules, what are the motion to dismiss and affirmative defense? Now, first, that the court has no jurisdiction over the person of the defending party. Under the old rules, it is a ground for motion to dismiss and can be raised in an affirmative defense. Whereas under the new rules, it is now prohibited as a ground for motion to dismiss. It can only now be raised as an affirmative defense. Now, first, reasons of the prohibited pleading is to, kasi dun sa rules, sabi sa amendments, yung reasons daw ng prohibited pleading is to reform procedural laws in order to make the disposition of every action and proceeding more just, speedy, and inexpensive, as well as to prevent delays and to decongest the courts. Kaya nagbawas na sila diyan ng grounds for motion to dismiss. So number 2, that the court has no jurisdiction over subject matter, yung subject matter jurisdiction. Under the old rules and new rules, same pa rin siya. So pwede siyang i-raise as a motion to dismiss and as an affirmative defense in the answer. Third, improper venue. Under the old rules, pwede sa motion to dismiss and pwede sa affirmative defense, but not under the new rules as a motion to dismiss. So it can only be raised as an affirmative defense. The same is true with the plaintiff has no legal capacity to sue. Pwede siya sa old rules, ngayon sa new rules, hindi na siya pwedeng i-raise as a motion to dismiss, but can only be raised as an affirmative defense in the answer. Next, yung litis pendentia and prescription and res judicata, under the old rules and new rules, same pa rin siya. It can be raised either in a motion to dismiss or in the answer, or as an affirmative defense in the answer. Number 7, that the pleading asserting the claim states no cause of action. Under the old rules, it can be raised as a motion to dismiss and affirmative defense in the answer, but now it can only be raised as an affirmative defense. So prohibited pleading na siya. Prohibited ground for motion to dismiss. Number 8, that the claim or demand set forth in the plaintiff's pleading has been paid, waived, abandoned, or otherwise extinguished. Under the old rules, pwede sa motion to dismiss and affirmative defense. Under the new rules, only through affirmative defense. 9, that the claim on which the action is founded is unenforceable under statutes of frauds. Under the old rules, yes, but under the new rules, affirmative defense na lang siya. The same is true with the condition precedent for filing the claim has not been complied with. Under the old rules, it can be raised as a motion to dismiss and affirmative defense, while under the new rules, it can only be raised as an affirmative defense. Now, under the old rule, yung Rule 16 requires hearing of the motion. So, nag-hear ang motion, magsasabit ng arguments, present ng evidence. So, it consume time talaga. Kaya dito, tinanggal na yung ibang mga grounds para ma-expedite nga ang proceedings. Before, it is only after the hearing of that motion and the denial of that motion that the movement can file his answer. So talagang nagtatagal dun sa intervening period. So ngayon parang tinanggal na yung ibang grounds to motion to dismiss, and they are considered now as prohibited motions. All right, next. Now, grounds under the new rules. Motion to dismiss and affirmative defense. So these are the grounds that can be raised in a motion to dismiss, and if it is not raised in a motion to dismiss, it can be raised as an affirmative defense in the answer. First, motion to dismiss, subject matter jurisdiction, litis pendentia, res judicata, and prescription. Pero sa rules, tatlo lang yan. Pinagsama kasi sa number 3. Dun sa section 12A, Rule 15, sabi niya that the cause of action is barred by a prior judgment or by statute of limitations. That refers to res judicata and prescription. Now, these are the grounds for affirmative defenses. So 1, same subject matter, litis pendentia, res judicata, and prescription. Kung makikita niyo, section 5, paragraph B, Rule 6 na siya. Pero dun sa motion to dismiss, dun siya sinite sa Rule 15, as section 12, paragraph A, Rule 15. Now, another affirmative defense that the court has no jurisdiction over the person of the defending party, improper venue, that the plaintiff has no legal capacity to sue, that the pleading asserting the claim states no cause of action, that the claim has been paid, waived, abandoned, or otherwise extinguished. Now, subject under section 13, Rule 15, subject to the right of appeal, an order granting a motion to dismiss or an affirmative defense that on these 3 grounds, that the cause of action is barred by a prior judgment or by the statute of limitation, res judicata, or prescription, and that the claim or demand set forth in the plaintiff's pleading has been paid, waived, abandoned, or otherwise extinguished, or that the claim on which the action is founded is unenforceable under the provisions of the statute of frauds, shall bar the repiling of the same action or claim. So these 4 grounds if praised in a motion to dismiss or an affirmative defense, shall bar the refiling of the same action or claim. Kasi yung iba pwede naman na dismissal without prejudice, it can refile. But based on these grounds, it will bar the refiling of the same action or claim. Other affirmative defenses, that the claim on which the action is founded is unenforceable under the statute of frauds, that the condition precedent for filing the claim has not been complied with, and under Section 5, Paragraph B, Rule 6, yung original na nakalagay doon, yung fraud, illegality, estoppel, former recovery, discharge in bankruptcy, any other matter by way of confession and avoidance are still affirmative defenses. So yan po ang matrix natin ng motion to dismiss and affirmative defenses. So dito sa matrix, hindi kayo malilito. Kasi kung sa rules, parang nakakalito minsan nga, nung una nga, nalito rin ako. So ngayon, mas maganda i-enable natin para madaling tingnan. Alright, now, let's move to dismissal of actions under Rule 17. What are the modes of dismissal under this rule? There are 4 modes: dismissal upon notice by plaintiff, dismissal upon motion by plaintiff, dismissal due to the fault of the plaintiff, and of course, the dismissal of counterclaim, cross-claim, or third-party complaint. Dismissal upon notice by plaintiff. The plaintiff, at any time before the service of an answer or a motion for summary judgment, may file a notice of dismissal of his or her complaint. In short, the plaintiff can file a notice of dismissal either first before service of an answer, or even after the service of an answer, but before a motion for summary judgment was filed. In this mode, the court will simply confirm the dismissal by issuing an order. Now, as a rule, the dismissal is without prejudice to the refiling of the complaint. So the dismissal under this rule is without prejudice. However, there are exceptions to this. When is the notice of dismissal with prejudice? The dismissal is with prejudice first when the notice of dismissal provides that the dismissal is with prejudice. Nakalagay with prejudice. Or when the plaintiff has previously dismissed by the same case in a court of competent jurisdiction. This is the 2 dismissal rule. In other words, dismissal upon notice of the refiled complaint, which was previously dismissed without prejudice, will operate as an adjudication on the merits. The second dismissal now is with prejudice. So that is the 2 dismissal rule. Okay, so that is dismissal upon notice by plaintiff. Second, dismissal upon motion by plaintiff. If an answer or a motion for summary judgment has been served on the plaintiff, so nakapag-file ng answer and nakapag-serve ng motion for summary judgment, the dismissal is no longer by way of notice, but by filing of a motion. In this mode, it will now subject to the approval of the court. Unlike in the notice of dismissal, the court will simply confirm the notice of dismissal. Dito, kailangan ng may approval ng court. Kasi nga by motion na siya. Now, if counterclaim was pleaded by the defendant, supposedly the defendant files and pleaded a counterclaim before the service of the plaintiff motion for dismissal. Now, what will happen to the defendant's counterclaim? If counterclaim was pleaded by the defendant after service upon him or her of the plaintiff's motion for dismissal, the dismissal of the complaint shall include the dismissal of the counterclaim. So, a counterclaim was pleaded by the defendant after service, the dismissal of the complaint will include the dismissal of the counterclaim. Now, if the counterclaim was pleaded by the defendant before service upon him or her of the plaintiff's motion for dismissal, the dismissal of the complaint shall be limited to the complaint. So that is a distinction. Counterclaim pleaded after and before. All right. Now that is the dismissal upon motion by the plaintiff. By the way, anyway, the defendant here can prosecute his or her counterclaim in a separate action unless within 15 calendar days from notice of the motion, he or she manifests his or her preference to have the counterclaim resolved in the same action. Now, in the case of Bly versus Bana 2018 case, the rationale behind the passing of the 15-day period triggers the finality of the court's dismissal of the complaint and hence bars the conduct of further proceedings. That is, the prosecution of counterclaim in the same action. Thus, in order to obviate this finality, the defendant is required to file the required manifestation within the aforesaid period. Otherwise, the counterclaim may be prosecuted only in a separate action. So, yung manifestation dapat within 15 calendar days. Kasi nga may effect yan dun sa finality ng judgment. So, dapat pag-manifest siya na whether he will want to resolve his or her counterclaim within the same action or in a separate action. Okay. Next mode is the dismissal due to fault of plaintiff. The complaint may be dismissed upon motion of the defendant or upon the court's motion when, 3 grounds lang po yan, plaintiff fails to appear on the date of the presentation of his or her evidence, or if the plaintiff fails to prosecute his or her action within a reasonable length of time, or when the plaintiff fails to comply with the rules of court or any order of the court. The dismissal in this case has the effect of an adjudication upon the merits, unless otherwise declared by the court. So this is the dismissal due to fault of plaintiff. All right. Next mode is the dismissal of counterclaim, cross-claim, or third-party complaint. So na-discuss natin yung iba kanina. The same rules in dismissal by notice and motion shall also apply to the dismissal of a counterclaim, cross-claim, or third-party complaint. A notice of dismissal shall be made before a responsive pleading or motion for summary judgment is served, or if there is none, before the introduction of evidence at the trial or hearing. So this is the dismissal of counterclaim, cross-claim, or third-party complaint. All right, now let's proceed to judgment on the pleadings and summary judgment under Rules 34 and 35. Judgment on the pleadings is proper when an answer fails to tender an issue or otherwise admits the material allegations of the adverse party's pleading under Section 1, Rule 34. In other words, there is no apparent issue at all because of the failure of the depending party's answer to raise an issue. Now, if an answer does in fact specifically deny the material allegations of the complaint and or asserts affirmative defenses like the statute of frauds, litispendentia, res judicata, or prescription, a judgment on the pleadings is not the proper remedy or it is unavailing. All right. Now, in the case of Adolfo versus Adolfo, 2015 case, an answer will fail to tender an issue if, first, it does not deny the material allegations in the complaint or admits said material allegations of the adverse parties to pleadings by confessing the truthfulness thereof and or omitting to deal with them at all. Okay, so ang ano dito yung the answer fails to tender an issue and admits the material allegations of the complaint. Now, question, may the court mutu proprio render judgment on the pleadings? Yes, if it is apparent that the answer fails to tender an issue or otherwise admits the material allegations of the adverse parties' pleadings, the court may mutu proprio render judgment on the pleadings. In other words, if it is apparent that the answer fails to tender an issue or otherwise admit the material allegations of the adverse parties' pleadings, the court may mutu proprio or motion of the party render on the pleadings. Now, tender of an issue, meaning it does that the answer failed to tender an issue if it does not comply with the requirements for a specific denial. And it would admit the material allegations of the adverse party's pleading, not only where it expressly confesses or the truthfulness thereof, but also if it omits to deal with them. Diba sinabi natin kanina? Now, if it is not apparent, next. If it's not apparent that the answer fails to tender an issue or otherwise admits the material allegations of the adverse party's pleadings, the motion shall be subject to Rule 15 on litigated motion. So, subject na sa Rule 15. So, kailangan na dyan ng notice of hearing, proof of service, and the court on its discretion conduct hearing. So, litigated motion na kasi. All right, now. Next. Question. Is the action of the court on a motion, so itong action of the court on a motion or judgment on the pleading subject to an appeal or petition for certiorari, prohibition, or mandamus? No. For first, action order denying the motion for judgment on the pleadings or action in a pre-trial order submitting the case for judgment on the pleadings. Is the judgment on the pleading subject to an appeal? So a distinction should be made. So first, action of the court on the motion. So dito sa pangalawa, judgment on the pleadings. On its the judgment on the pleadings proper. Yes, an appeal may be taken from a judgment or final order that completely disposes of the case or of a particular matter therein under Rule 41. So final judgment na kayo. So pwede siyang subject on appeal. Pero sa first action of the court lang, yung ibawa, dineny yung motion for judgment of the pleadings or sa pre-trial order, dineny submitting the case for judgment on the pleadings. So ito kasi nakalagay na kasi ito sa rules na an action for the judgment on the pleading subject to is not subject to an appeal or petition for certiorari, prohibition, or mandamus. But the judgment on the pleading itself is subject to an appeal because it is a final judgment or order that completely disposes of the case. All right. Now, summary judgment. Summary judgment is proper where the pleadings, supporting affidavits, depositions, and admissions on file show that except as to the amount of damages, there is no genuine issue as to any material fact. Genuine issue, it is an issue of fact which requires the presentation of evidence as distinguished as sham, fictitious, contrived, or false claim. Now, but when the facts as pleaded appear undisputed, then there is no genuine issue or question as to the facts, thus summary judgment would be proper. So the keyword here is that no genuine issues as to any material fact. So may issue pero hindi nga genuine. Parang ganun. Anyway, now, judgment on the pleadings, there is no apparent or ostensible issue at all. Walang issue. Summary judgment, there is apparent or is ostensible issue, but the same is sham, fictitious, or not genuine. So that is the distinction between judgment on the pleadings and summary judgment. Judgment on the pleadings may issue, summary judgment may issue pero hindi genuine. It is sham, fictitious, or not genuine. Okay. Now, in the case of Gubat versus NPC, for summary judgment to proceed in lieu of a full-blown trial, the party who moves for summary judgment has the burden of demonstrating clearly the absence of genuine issues of fact or that the issue posed is patently insubstantial as to constitute a genuine issue. Now, how can the movement demonstrate that it has no genuine issues? It can demonstrate through the pleadings, the supporting affidavits, the deposition, and admissions on file. Now, in the case of Globe Asiatic versus Union Bank 2019 case, the court ruled that the pleadings submitted by the parties clearly show conflicting allegations between them, making the facts disputed. Consequently, petitioner failed to discharge its burden of showing that there was no genuine issue to be tried. Kasi may conflicting allegations. So, hindi ma-determine yung genuine issue of the of that case. Okay. Now, also in the case of trade and investment development versus Philippine Veterans Bank, a 2019 case, an order or resolution granting a motion for summary judgment which fully determines the rights and obligations of the parties relative to the case and leaves no other issue unresolved except the amount of damages is a final judgment. In Ivernas versus Tanco Gabaldon 2011 case, in leaving out the determination of the amount of damages, a summary judgment is not removed from the category of final judgment. So kahit walang determination so dun sa damages, it is still a final judgment. Okay. Question. Is the action of the court on a motion for summary judgment subject to an appeal or petition for certiorari, prohibition, or mandamus? This is the same question dun sa judgment on the pleadings. So dito sa summary judgment, is the action of the court on a motion for summary judgment subject to an appeal, certiorari, prohibition, or mandamus? The answer is no. Again, same. For action order denying the motion for summary judgment or action in a pre-trial order submitting the case for summary judgment. But if the summary judgment proper or summary judgment itself subject to an appeal, yes, an appeal may be taken from a judgment or final order that completely dispose of the case or of a particular matter therein. So distinction again. So first, yung action of the court on a motion for summary judgment. So example ngayon, yung action order denying the motion for summary judgments, tsaka yung action ng courts in a pre-trial order submitting the case for summary judgment. So yun, hindi pwedeng i-appeal or i-subject sa certiorari, prohibition, or mandamus. But the summary judgment itself is subject to an appeal because it is a final order that completely disposes of the case. Final judgment order. All right, now that is all about the summary judgment and judgment on the pleadings. Let us proceed to pre-trial under Rule 18. Pre-trial is mandatory in all civil cases and criminal cases. Cognizable by the Sandigan Bayan, Regional Trial Court, Municipal Trial Courts, Metropolitan Trial Courts, and Municipal Circuit Trial Court. In civil cases, it is mandatory. Ganun din sa criminal cases. Now, what is the effect if the plaintiff and the defendant and their counsels fails to appear? So, halimbawa, hindi nag-appear yung plaintiff or defendant or their counters or their respective counsels. Now, what is the effect? Now, the failure of the plaintiff and counsel to appear without a valid cause, so walang valid cause, shall be cause for the dismissal with prejudice of the action, unless, of course, the court orders otherwise. Now, on the other hand, if the defendant or his or her counsel fails to appear without valid cause, it shall cause to allow the plaintiff to present his evidence ex parte and for the court to render judgment on the basis of the evidence presented or offered by the plaintiff. Now, what is the effect of if the parties fail to file a pre-trial brief? Still, the same shall have the effect as failure to appear during the pre-trial. Now, in Benavides versus Salvador 2013 case, both parties and their counsels are mandated to appear at a pre-trial except for first, a valid excuse and appearance of a representative on behalf of a party who is fully authorized in writing to enter into an amicable settlement, to submit to alternative modes of dispute resolution, and to enter into stipulations or admissions of facts and documents. So as a rule, mandated, but if there is a valid excuse and the appearance of a representative on behalf of a party who is fully authorized in writing or is authorized in writing, then it can be excused. Pagkat the court will, depende naman sa court. All right, now, question. May the court mutu proprio submit the case for summary judgment? Napalaga na yun. For judgment of the pleadings in its pretrial order. So, may the court mutu proprio submit the case for summary judgment or judgment on the pleadings in its pretrial order? Ito na pala yung bagong rules. Yes, should there be no more controverted facts or no more genuine issue as to any material fact or an absence of any issue, or should the answer fail to tender an issue, the court may mutu proprio include in the pretrial order that the case be submitted for summary judgment or judgment on the pleadings without need of position papers or memoranda. In such cases, the judgment shall be rendered within 90 calendar days from termination of the pre-trial. But of course, this is without prejudice to a party moving for a judgment on the pleadings under Rule 34 and summary judgment under Rule 45. So pwede naman siya mag-file na judgment of pleading or summary judgment. Pero dito sa pre-trial, pwede na mag-order ang judge to include that in the pre-trial order. Now, is the action of the court to submit the case for summary judgment or judgment on the pleadings in the pre-trial order subject to an appeal or petition for certiorari? So kanina yung action ng court sa judgment on the pleadings and summary judgment. Dito naman yung action ng court to submit the case for summary judgment in its pre-trial order. Pwede ba yun na subject sa appeal, petition for certiorari? No, under the new rules. The action of the court in a pre-trial order submitting the case for summary judgment or judgment of the pleadings is not subject to appeal or certiorari. So tatlo lang naman yan, yung action of the court, action of the court in judgment on the pleadings, second, action of the court in summary judgment, and action of the court to submit the summary judgment or judgment of the pleadings in a pretrial order is not subject to an appeal or petition or certiorari or provision or mandamus. Now, is the summary judgment or judgment on the pleading subject to an appeal? Siyempre, kasi an appeal may be taken from a judgment or final order that completely disposes of the case or a particular matter therein. Ito yung summary judgment or judgment of pleadings proper. Now, let's move to modes of discovery. So, mga important points lang kasi medyo mahaba po ito, modes of discovery. Depositions. First, depositions. The testimony of any person may be taken by deposition upon oral examination or written interrogatories at the instance of any party. So, deposition can be taken by oral examination or written interrogatories. Now, depositions serve as a device for narrowing and clarifying the basic issues between the parties, as well as for ascertaining the facts relative to those issues. The purpose of deposition is to enable the parties consistent with recognized privileges to obtain the fullest possible knowledge of the issues and facts before trial. Now, in the case of Dasmariñas Garments versus Reyes, depositions and the other modes of discovery, such as the interrogatories to parties, requests for admission by adverse party, production or inspection of documents or things, or physical and mental examinations of persons are meant to enable a party to learn all the material and relevant facts not only known to him and his witnesses, but also those known to the adverse party and the latter's own witnesses. So yun ang purpose in deposition and other modes of discovery. Now, in other words, the object of discovery is to make it possible for all the parties to a case to learn all the material and relevant facts from whomever they may have knowledge thereof, or to the end that the that the pleadings or motions may not suffer from inadequacy of factual foundation, and all the relevant facts may be clearly and completely laid before the court without omission or suppression. All right. Now, in the case of Martyrs versus Heirs of Sumera, a 2018 case, a petition for certiorari to question the admission and evidence of the depositions is not the proper remedy. So, hindi yung proper remedy. The admission or rejection of certain interrogatories in the course of discovery procedure could be an error of law, but not an abuse of discretion. So, naman. Much less a grave one. The procedure for the taking of depositions, whether oral or through written interrogatories, is outlined in the rules, leaving no discretion to the court to adopt any other substantially equivalent thereto. Consequently, if the judge deviates from what the rule prescribes, he commits a legal error, not an abuse of discretion. Thus, the appeal, and not certiorari, is the proper remedy for the correction of any error as to the admission of depositions and to evidence. That's the case of Martyrs versus Heirs of Sumera, 2018 case. Now, in the case of BDO Strategic Holdings versus Asia Amalgamated at 2019 case, the court ruled that it is true that depositions are legal instruments consistent with the principle of promoting the just, speedy, and inexpensive disposition of every action or proceeding. It is important to be reminded that the right to take deposition, whether in a form of oral or written interrogatories, has limitations. May limitation. The rules of court expressly provides for limitations to deposition. First, that is when the examination is being conducted in bad faith or in such manner as to annoy, embarrass, or oppress the person subject to the inquiry, or when the inquiry touches upon the irrelevant or encroaches upon the recognized domains of privilege. So yung marital privilege, privilege communication. That is the case of BDO Strategic Holdings versus Asia Amalgamated. So it will not apply if there's a bad faith, and it will encroach the domain of privilege. In this case of the BDO failed to establish the disallowance by the lower court. The lower court was made arbitrarily, capriciously, or oppressively to warrant a reversal. The court further note that considering that the case is in the cross-examination stage already, so nasa cross-examination na, the use of written interrogatories will not serve its purpose anymore. Kasi usually ito ginagawa mo sa discovery for trial. So ito nasa cross-examination stage na, as trial na. It cannot aid in the preparation and speedy disposition of the pending case. Instead, it will only cause further delay in the proceedings. The facts which the written interrogatories want to elicit can be extracted from the continuation of the cross-examination. The mere allegations of BDO that the subjects of the written interrogatories are relevant to the case and not made in bad faith or in a manner intended to annoy, embarrass, or oppress are not sufficient basis to revisit the factual evidence involved. It is also important to remember that inquiry in written interrogatories should not only be relevant to the case, but also made in good faith and within the bounds of the law. So that's the case of BDO. Next, modes of discovery, request for admission. In Duque versus U, a 2018 case, the court ruled that once a party serves a request for admission as to the truth of any material and relevant matter of fact, the party to whom such request is served has 15 days within which to file a sworn statement answering it. In case of failure to do so, each of the matters of which admission is requested shall be deemed admitted. This rule, however, admits of an exception. That is when the party to whom such request for admission is served has already controverted the matters subject of such request in an earlier pleading. So, for example, nagpahit siya ng answer. controverted na ang issue. May admissions na. Otherwise stated, if the matters in a request for admission have already been admitted or denied in previous pleadings by the requested party, the latter cannot be compelled to admit or deny them anew. In turn, the requesting party cannot reasonably expect a response to the request and thereafter assume or even demand the application of the implied admission rule in Section 2 of Rule 26. Now, in the case of Metro Manila Shopping Mecca versus Toledo 2013 case and the case of Duque versus U 2018 case yung kanina, the rationale is that the admissions by an adverse party as a mode of discovery contemplates of interrogatories that would clarify, intend to shed light on the truth or falsity of the allegations in a pleading, and does not refer to a mere reiteration of what has already been alleged in the pleadings, or else it constitutes an utter redundancy and will be a useless, pointless process which petitioner should not be subjected to. Okay, now. So, okay na tayo dun sa modes of discovery. So, yun naman importante na may decision ng Supreme Court. Now, let's move to the bureau or the marrer to evidence under Rule 33. The marrer to evidence or the bureau to evidence is a motion to dismiss on the ground of insufficiency of evidence. And Felipe versus MGM Motor 2015 case, the court ruled that the bureau or the marrer to evidence is a remedy available to the defendant to the effect that the evidence produced by the plaintiff is insufficient in point of law, whether true or not, to make out a case or sustain an issue. Now, the question in the bureau or the marrer to evidence is whether the plaintiff, by his evidence in chief, had been able to establish a prima facie cases. Note that in a demurrer to evidence or the marrer to evidence, it is premature to speak of preponderance of evidence because it is filed prior to the defendant's presentation of evidence. It is precisely the office of the demurrer or the marrer to evidence to expeditiously terminate the case without the need of the defendant's evidence. Okay. In Oropesa versus Oropesa 2012 case, the court affirmed the dismissal of the case on demurrer to evidence due to plaintiff's non-submission of the formal offer of evidence. Demurrer or demarrer to evidence is an objection by one of the parties in an action to the effect that the evidence which has adversary produced is insufficient in point of law, whether true or not, to make out a case or sustain the issue. A demurrer or demarrer to evidence authorizes a judgment on the merits of the case without the defendant having to submit evidence on his part, as he would ordinarily have to do if plaintiff's evidence shows that he is not entitled to the relief sought. Okay, question. When is demurrer or demarrer to evidence proper? In Spouses Condor versus CA 2007, the court ruled that first, when upon the facts and the law, the plaintiff has shown no right to relief. Second, where the plaintiff's evidence together with such inferences and conclusions as may be reasonably drawn therefrom does not warrant recovery against the defendant. Third, when admitting every proven fact favorable to the plaintiff and indulging in his favor all conclusions fairly and reasonably inferable therefrom, the plaintiff has paid to make out one or more of the material elements of his case, or when there is no evidence to support an allegation necessary to his claim, and when the plaintiff's evidence is prima facie insufficient for a recovery. All right. Now, what is the effect of motion for judgment on demurrer or demarrer to evidence? If the motion is denied, the defendant shall have the right to present his or her evidence. So, such denial does not deprive the defendant to adduce evidence on his behalf. An order denying the demurrer to evidence shall not be subject of an appeal or petition for certiorari, prohibition, or mandamus before judgment. What about if the motion is granted? The case shall be dismissed with prejudice. However, if reversed on appeal, the defendant shall be deemed to have waived his or her right to present evidence. Now, question, can the appellate court remand the case for further proceedings? So, halimbawa, grinan, tapos, if remand for further proceedings, can the appellate court do that? No. It should render judgment based on the evidence presented by the plaintiff. Okay. That is all about demurrer or demurrer to evidence. Now let's proceed to consolidation, Rule 31. What is the effect of failure to consolidate a case with a related case? In the case of Goodland Company versus BDO Incorporated 2019 case, failure to consolidate a case with a related case does not necessarily result in the dismissal of the case, unless there is litis pendentia or res judicata. The action pending between the same parties for the same cause, the action is barred by res judicata or by prior judgment. Now, consolidation is a procedural device granted to the court as an aid in deciding how cases in its docket are to be tried, so that the business of the court may be dispatched expeditiously and with economy while providing justice to the parties. Though there is no hard and fast rule requiring the consolidation of related cases, Section 1, Rule 31 of the Rules of Court allows the court to order the consolidation of cases involving a common question of law or fact that are pending before it in order to avoid unnecessary cost or delay. So yun naman ang pinaka-purpose ng consolidation. Okay, now let's proceed to rendition of judgments under Rule 36. A judgment or final order determining the merits of the case shall be in writing, personally and directly prepared by the judge, stating clearly and distinctly the facts and the law on which it is based, signed by him and filed with the clerk of court. Now, this is in consonance with Section 14, Article 8 of the Constitution, which expressly provides that no decision shall be rendered by any court without expressing therein clearly and distinctly the facts and the law on which it is based. Now, in the case of Go versus East Ocean Leasing 2018 case, the RTC resolved all the issues that it had enumerated in the decision. The only problem is that the issues it resolved pertain exclusively to the damages cases, when it was tasked to decide all the issues in both the damages case and the collection case. Simply put, the RTC failed to include in its listing and to resolve the issues relating to the collection case, which are expressly provided in the pretrial order. Thus, the decision is void insofar as the collection case is concerned. So, now let's move to new trial or motion for reconsideration of judgment. Motion for new trial or motion for reconsideration under Rule 37. Motion for new trial, it should be filed with a period for taking an appeal. Grounds: fraud, accident, mistake, or excusable negligence. This fraud, accident, mistake, or excusable negligence, this must be grounds which an ordinary prudence could not have guarded against, and by reason of which such aggrieved party has probably been impaired in his rights. The other ground is newly discovered evidence. Newly discovered evidence which the movement could not, with reasonable diligence, have discovered and produced at the trial, and which, if presented, would probably alter the result or alter the outcome of the case. Under Section 2, Rule 37, the motion for new trial on the ground of newly discovered evidence must be supported by affidavits of the witnesses or by duly authenticated documents. The affidavits required here is an affidavit of merit, which states the facts constituting the movement's good and substantial defense, which he may prove if the motion is granted. Now, in Ivernas versus Tangco Gabaldon 2011 case, the requisites of a motion for new trial on the ground of newly discovered evidence are: first, the evidence was discovered after trial. Second, such evidence could not have been discovered and produced at the trial, even with the exercise of reasonable diligence. Third, it is material, not merely cumulative, corroborative, or impeaching. And number four, the evidence is of such weight that it would probably change the judgment if admitted. So that if the alleged evidence could have very well been presented during the trial, not after the trial, with the exercise of reasonable diligence, the same could not be considered newly discovered evidence. So dapat after the trial, the discovered evidence. Okay, next. Motion for reconsideration. It should be filed with a period of taking an appeal. Grounds: first, the damages awarded are excessive. Second, the evidence is insufficient to justify the decision or final order, or the decision or final order is contrary to law. This is a ground for motion to dismiss. However, under the rules, motion for reconsideration is allowed only on these grounds. And only one motion for reconsideration is allowed. So isa lang pwede. Last, isa lang talaga. Okay, next question. Is introduction of newly discovered additional evidence a ground for motion for reconsideration? Kasi sa new trial, pwede siya, di ba? Newly discovered evidence. Pwede rin po ba siya sa MR? No, in PDIC versus Gidwani 2018 case, judicial proceedings even prohibit the practice of introducing new evidence on reconsideration, since it potentially deprives the opposing party of his or her right to due process. In CSAN versus NLRC 2008 case and PDIC versus Gidwani in that case, while quasi-judicial bodies in administrative proceedings may extend leniency in this regard and allow the admission of evidence offered on reconsideration or on appeal, this is merely permissive and does not translate to a requirement of attaching additional evidence to support motions for reconsideration. Sa quasi-judicial body, pwede yun. Kasi di ba, alam naman natin in quasi-judicial bodies or agencies, they are not bound by the technical rules of procedure governing in the ordinary courts. So pwede siya. But sabi, it is merely permissive. But it does not translate to a requirement of attaching additional evidence to support MR. Hindi pwede. Okay. That is MR and new trial. Now let's proceed to relief from judgments under Rule 38. Petition for relief from judgment is an equitable remedy allowed in exceptional cases when there is no other available or adequate remedy that will allow for substantive justice. Now, under this petition for relief from judgment, when a party has another remedy available, which may either a motion for new trial or appeal from an adverse decision of the trial court, and it was not prevented by fraud, accident, mistake, or excusable negligence from filing such motion or for taking an appeal, he cannot avail of this petition for relief from judgment. Kasi mayroon siyang available remedies and adequate remedies. Now, what are the grounds for this petition? Fraud, accident, mistake, or excusable negligence. Fraud here refers to extrinsic or collateral fraud, meaning the fraud has prevented the unsuccessful party from fully and fairly presenting his case or defense, and the losing party from having an adversarial trial of the issues. Example, the lawyer connives to defeat or corrupt, sells out his client's interest. So that is a fraud, an extrinsic and collateral fraud. Now, mistake here, mistake of fact, not mistake of law. So hence, a wrong choice of legal strategy or mode of procedure, neither it refers to judicial error committed in the trial. In a way, such kung may a judicial error man, it may be corrected on appeal, but not here in petition for relief from judgment. And last, excusable negligence. Excusable negligence requires that the negligence is so gross. Kailangan gross, hindi simple negligence. It is so gross that ordinary diligence and prudence could not have been guarded against it. Okay, now in the case of spouses versus Court of Appeals 2005 case, this excusable negligence must also be imputable to the party litigant and not to his or her counsel, whose negligence binds his or her client. So itong excusable negligence po, not yung fraud, kasi yung fraud refers to extrinsic or collateral fraud. But here, excusable negligence must be imputable to the party litigant and not to his or her counsel. However, in several cases decided by the Supreme Court, the court relaxed this rule, such as first, when the gross negligence of counsel deprives the client of due process of law, or when the rule's application will result in outright deprivation of the client's liberty or property, or when the interest of justice so required. But certainly, excusable negligence must be proven. Okay, now. All right, next. When to file petition for relief from judgment. The petition for relief from judgment must be filed within first 60 days from knowledge of the judgment, order, or other proceeding to be set aside, and 6 months from the entry of such judgment, order, or other proceeding. Ito yung double period rule. 60 days from knowledge of the judgment and 6 months from the entry of such judgment. In short, the reglementary periods for the petition for relief from judgment must be reckoned from the petitioner's knowledge of the judgment as well as on the date it was entered. Now, these two periods must concur and must be strictly observed because such reglementary period is jurisdictional. If filed beyond these periods, the petition may be dismissed outright, or the court will lose jurisdiction. Now, for purposes of the 60 days from knowledge of judgment, knowledge of the finality of the judgment, yung entry, is irrelevant. Under Rule 36, diba, the date of finality of judgment shall be deemed the date of its entry. So remember this double period rule. So kailangan mag-concur to 60 days from knowledge of the judgment and 6 months from entry of such judgment. Now in Queldan versus VHF, Philippines 2005, said periods could not be extended and could never be interrupted. So it is not extendable or not interruptible. So remember the double period rule. Okay, next. Now, question. If the petition is grounded on extrinsic fraud, will the double period rule apply absolutely yung 60 days and 6 months. In the case of Duremdes versus O'Reilly et al. 2020 case, the court ruled no. The above stated rule will not apply when a petition for relief, which is grounded on extrinsic fraud, ultimately results in the court's lack of jurisdiction over the defendant, and which consequently makes the judgment rendered by the trial court void. In such a case, the petition for relief should not be dismissed for failure of one to avail himself of the remedy of an appeal and for untimeliness. Dito sa case ng Duremdes, the respondent here committed extrinsic fraud by providing the court an erroneous address where summons may be served on petitioner. Thus, the RTC decision is void for lack of jurisdiction over the petitioner, no jurisdiction over the person, and thus the petitioner assailed that decision the petitioner may assail that decision at any time, even after the double period rule of 60 days from notice of judgment and 6 months from entry of judgment. Sabi natin kanina, hindi siya not extendable, not uninterruptible. Pero here, in the case of Duremdes, pwede kasi it will ultimately results in the court's lack of jurisdiction over the defendant. Okay, next. In the case of Lasam versus PNB 2018 case, as an equitable remedy, strict compliance with the applicable reglementary periods for its filing must be satisfactorily shown, because a petition for relief from judgment is a final act of liberality on the part of the state, which remedy cannot be allowed to erode any further the fundamental principle that a judgment must at some definite time attain finality in order to put an end to litigation. Okay. Can the petitioner file a petition for relief from judgment in the Court of Appeals? Asel in Porcon versus MRM, Philippines 2008, no. It is settled that a petition for relief from judgment is not an available remedy in the Court of Appeals. While Rule 38 uses the phrase any court, it refers only to municipal, metropolitan, and regional trial courts. The procedure in the Court of Appeals and the Supreme Court are governed by separate provisions of the rules of court and may from time to time be supplemented by additional rules promulgated by the Supreme Court through resolutions or circular. As it stands, neither the rules of court nor the revised internal rules of the Court of Appeals allow the remedy of petition for relief in the Court of Appeals. So hindi pwede po ang petition for relief from judgment sa Court of Appeals. Next, annulment of judgments under Rule 47. Petition for annulment of judgment is a remedy granted only under exceptional circumstances where a party without fault on his part had failed to avail of the ordinary or other appropriate remedies provided by law, and such action is never resorted to as a substitute for a party's own neglect in not promptly availing of the ordinary or other appropriate remedies, as said in Republic versus Castro. Now, in other words, the remedy of petition for annulment of judgment can only be availed where the ordinary remedies of new trial, appeal, petition for relief, or other appropriate remedies are no longer available without the fault of the petitioner. Now, what are the grounds for petition for annulment of judgment? Grounds: first, extrinsic fraud. Second, lack of jurisdiction. Third, denial of due process, as held in the case of Barcelona versus CA and the subsequent cases. Now, extrinsic fraud here refers to collateral fraud, meaning the fraud has prevented the unsuccessful party from fully presenting his case or defense and the losing party from having an adversarial trial of the issue. Now, the overriding consideration when extrinsic fraud is alleged is that the fraudulent scheme of the prevailing litigant prevailing litigant prevented the petitioner from having his day in court. Again, extrinsic fraud is not a valid ground if it is availed of or could have been availed in a motion for new trial or petition for relief. Now, this lack of jurisdiction refers to lack of jurisdiction over the person of the defendant and lack of jurisdiction over the subject matter of the case. So, next. In Thomas versus Trono 2021 case, as guardians of constitutional rights, courts cannot be expected to deprive persons of their rights to due process while at the same time be considered as acting within their jurisdiction. Where the denial of the fundamental right of due process is apparent, a decision rendered in disregard of that right is void for lack of jurisdiction. In Sarol versus Spouses Jiao, in this case, had there been the proper service of summons, kasi nagkamali, wrong address yung binigay, the petitioner would have had such remedies as a motion for new trial, appeal, petition for relief from judgment, among others, to assail the decision of the RTC. In view of the failure to properly serve summons, the petitioner could not have learned of the case and had no other recourse but to file a petition for relief from judgment. Petition for annulment of judgment under Rule 47. In the case of Pinausukan Seafood House versus Paris Bank 2014 case, the remedy of annulment of judgment, although seen as a last remedy, is not an alternative to the ordinary remedies of the new trial, appeal, and petition for relief. The petition must aver, therefore, that the petitioner failed to move for a new trial or to appeal or to file a petition for relief without fault on his part. But this requirement to aver is not imposed when the ground for a petition is lack of jurisdiction, whether alleged singly or in combination with extrinsic fraud, simply because the judgment or final order being void may be assailed at any time, either collaterally or by direct action or by resisting such judgment or final order in any action or proceeding whenever it is invoked, unless the ground of lack of jurisdiction is meanwhile barred by laches. Note, however, that the remedy of petition for annulment of judgment can only be availed where the ordinary remedies of new trial, appeal, petition for relief, or other appropriate remedies are no longer available without the fault of the petitioner. Okay. Now, in the case of Combs versus Castañeda, 2017 case, the Court of Appeals dismissal based on technical grounds, that is failure to allege that she did not avail of a motion for new trial, appeal, petition for relief, or other appropriate remedies, was also erroneous. First, when a petition for annulment of judgment is grounded on lack of jurisdiction, the petitioner need not allege that the ordinary remedy of the new trial or reconsideration of the judgment sought to be annulled are no longer available through no fault of her own. This is because a judgment rendered without jurisdiction is fundamentally void. Thus, it may be questioned anytime unless laches has already set in. So, pag lack of jurisdiction ang ground, so hindi na kailangan i-allege. But pag extrinsic fraud, so kailangan i-allege niya. Kasi pwede pa rin siyang pwede mo siyang erase dapat noon sa MR, sa motion for new trial, appeal, and petition for relief. All right. Now, in the case of Ancheta versus Cambay, 2021 case, considering that the ground relied upon in the petition for annulment is lack of jurisdiction over the persons of petitioner, it was not necessary, nor was it essential on the part of the Court of Appeals to establish first, before it could have ruled on the merits of the petition for annulment, whether the remedy of petition for relief was earlier availed of. While the petitioner had previously availed of the remedy of a petition for relief from the RTC, she is not precluded from filing with the Court of Appeals a petition for annulment of judgment, one that is essentially anchored on the ground of lack of jurisdiction. So again, distinguish extrinsic fraud or lack of jurisdiction. Okay. Now, when to file petition for annulment of judgment? If the petition for annulment of judgment is based on the ground of extrinsic fraud within 4 years from discovery of the fraud. Now, if it is based on the ground of lack of jurisdiction before it is barred by laches or estoppel. Now, laches or estoppel or estoppel by laches is the failure to timely raise a court's lack of jurisdiction, ultimately resulting in a binding judgment. Not because said judgment is valid as an adjudication, but because public policy looks with disfavor on the belated invocation of jurisdictional issues. Now, in the case of the heirs of Collado versus Gutierrez 2019 case, considering that the petitioner had already availed himself of the remedy of a petition for relief from judgment under Rule 38, raising the issue of extrinsic fraud with the trial court, the petitioner is effectively barred from raising the same issue via his petition for annulment of judgment. However, the same cannot be said for the ground of lack of jurisdiction, considering that the petitioner immediately resorted to court action, that is, a petition for relief from judgment and a petition for annulment of judgment. Upon learning of the unfavorable decision of the trial court, he cannot be deemed guilty of laches nor placed in estoppel. Thus, if the petitioner is able to prove that the trial court indeed went beyond its jurisdiction in issuing its decision, nothing prevents him from asking for its annulment. Now, which court has jurisdiction over an action for annulment of judgment? RTC judgment, Court of Appeals, MTC judgment, Regional Trial Court. Now, suppose it is a judgment of a quasi-judicial body, example, the SEC, DARA, is annulment of judgment before the Court of Appeals an available remedy? No, as in the case of Imperial versus Armis. By the way, I was advised by our host, by the Gothic publication, that we exceeded the time limit for this presentation. Parang almost 4 hours na po yata. So anyway, we will continue this lecture to be announced by the Gothic publications in the official page kasi medyo mahaba-haba pa. So kulang talaga pala kasi rule jurisdiction, rule 1 hanggang rule 38, rule 38 and 47 pa lang tayo. Anyway, we'll continue this. So please tune po sa ating FB page ng Gothic Publications and kindly like and follow na lang po ang ating Gothic publication. Gothic publication. So we'll see you on the next lecture. So abang-abang na lang and baka mag-post. At sana po nagustuhan nyo. Sana nag-enjoy kayo. Kaya po ginawa nating medyo malaking PowerPoint para pwede nyo kopyahin kasi pag yung ano lang, parang nakakatamad, gusto lang makinig. Dito makapagbasa kayo, pwede nyo picturean, pwede nyo isulat. So sinimplified natin. So we're trying to simplify it. So, medyo mahaba talaga yung remedial law. At sana po nag-enjoy kayo lalo sa means. So naglalagay tayo lagi ng means para matuwa at pampalis antok. So parang nabubuhay tayo minsan-minsan. So nakikita natin yung mga means. So sana related naman. So hindi naman. So maraming salamat and sana po magkita ulit tayo. And good luck po sa mga magbabar and sa mga nag-review, sa mga estudyante. Sana po nakatulong ang aming lecture. At sana po ay tama yung aming share. Baka naman. Sana na simplify natin at sana maganda yung presentation. Huwag po kayo mag-alala sa mga next nating presentation. We will improve and we will update pa rin and of course, pagandahin pa natin ang ating presentation. So again, thank you and we'll see you again in the next live stream or presentation of the Gothic Publications. Maraming salamat po sa inyo. God bless po sa inyong lahat. So stay safe po kung saan man po kayo naroon. Maraming salamat po. Thank you.